the first case we're going to call this morning is Gilliam versus Allen, and Mr. McClatchy, we'll hear from you first.
Thank you, Your Honors, and may it please the Court. This case needs no introduction to this panel. This Court explained on its remand in the year 2019 that what happened in the two interview rooms at the Red Springs Police Department of that night in September 1983 were at the heart of this case. As the panel knows, the case proceeded to trial in May of 2021. It resulted in what has been called by the media the largest wrongful conviction verdict in the history of the United States. That verdict, however, was the product of a trial that was infected with a lot of error. The district court on remand determined how the case was going to play out, and it did what it could to steer the case there at every juncture. First, the district court told the jury that the plaintiffs were innocent, factually innocent for purposes of the civil case, and the district court did its best to preempt any contrary theory from the defendants wherever it could.
Let me ask you about that.
Yes.
I've thought a lot about this pardon, and as I was reading the case, a lot of time was spent at the trial talking about it, and some time passed, I was a district judge, and I tried to figure out what would have I done with that. And it's not an easy call, but I'm wondering, number one, why the pardon was offered into evidence and admitted in evidence at all, because the only necessary element would be the court's reversal of the verdict and release of the defendant. And the second is the enormous attention that was paid to the pardon during the course of the trial. People tried to talk whether he was innocent or guilty or factually this, and they talk about it, and the judge would give an instruction. Did you object to the entry of the pardon and even the information about the pardon?
Yes, Your Honor. That was the subject of a motion in limine, and there was a hearing on that on March 17th of 2021, not long before the trial. And during that hearing, the district judge told us, you are not going to impeach the pardon. The pardon is the word of the state. The governor declared them innocent, and basically you're not going to get anywhere around that.
Well, I understand that, but you know, pardons cover the full range. It could have been that the governor pardons a former playmate that he played over the years with, and he liked him, and he just pardoned him, and that we don't go behind the pardons. But the question, my question is, why was the pardon even an element of evidence?
Well, I believe it wasn't.
Did you object to the introduction of a pardon at all?
I'm sorry?
Did you object to the presentation of the pardon information at all?
It was, yes. The motion in limine was to exclude it altogether, and that was denied. And so the pardon was part of the case. And then the issue, Your Honor, and you pointed out that for purposes of satisfying the favorable termination element of a malicious prosecution claim, the plaintiffs needed only to show favorable termination. And that element was satisfied by the ruling on the motion for appropriate relief in Superior Court, where the judge granted that.
That was my view. That's probably where it should have ended. But
I would agree. Because the pardon, what happened, Your Honor, then, once it was in, it was the preclusive effect of the pardon.
But you never did, to go back to Judge Niemeyer's question, you did not object at trial. I heard about the motion in limine, but you did not object at trial to the introduction of the pardon, correct? Or not? I never heard an answer.
I don't know. I don't recall that there was specific objection at trial because the ruling on the motion in limine was conclusive. There was no wiggle room like, well, I'll review it later. It was, no, your motion is denied, and the plaintiffs also moved simultaneously, Your Honor, for a ruling that it was admissible. And so the judge's ruling on the motion in limine was to deny ours and grant the plaintiffs.
Well, it also seemed like a large part of appellant's argument at trial was to say that they were not innocent.
So the way...
And that is what caused the court to manage the trial the way it did.
The court managed, I believe, the trial the way it did was because the court misinterpreted the effect of the pardon and made it conclusive.
What was appellant's theory of the case? Did appellant not continue to argue that they, or at least give the impression that that they were not innocent?
Right, the
That
plaintiff's
the
theme...
confessions were valid?
Right, the plaintiff's theme...
So you're saying, right, that was the theory?
The defense theory at trial was that what was on those written confessions did in fact come out of the plaintiff's mouths in that interrogation room. The plaintiff's theory, on the other hand, was no, those were coerced, those were fabricated, they were told to sign them, they were something else. So it became essential for us.
Right, because that is, as you said at the beginning of your argument, that was the heart of the case.
Yes, Your Honor.
Whether the confessions were coerced or not. So I don't know why appellants were so intent on proving the plaintiff's guilty. You could argue they weren't coerced without all of that, couldn't you?
Not in this case, Your Honor, because what happened here was that the way the plaintiff's case was presented was that the confessions were coerced. They produced expert testimony. Why would an innocent person confess? Well, when they're coerced. And so you have the district court repeatedly telling the jury they are innocent. It is, in the judge's words, conclusive. At another point, they are innocent for purposes of this trial.
Right.
And so you have the jury being told they're innocent, they're innocent, they're innocent, plus expert testimony. Well, why does an innocent person confess? Oh, because they're coerced. So
here's the rub I've got. So the question I've got is understanding why you wanted to argue that they committed these crimes and therefore their confessions were true and therefore that's suggestive that they're not coerced. But so I understand that side, but you know, the judge here makes a judgment that like this executive branch determination, a pardon of innocence, goes to the evidence that weighs there. Just like we might introduce a conviction to prove the existence of guilt, the pardon of innocence is some evidence. And so, you know, I'm not sure, like Judge Niemeyer, I don't know whether I would have done that or not, but given the discretion we give to the district court in letting juries sort of see the facts and make a determination, you get to argue they did it. They get to argue they didn't do it. What's wrong with that? That's what juries do, right?
what Your Honor is referring to is the simple, what I say, foundational issue of it coming into evidence. What the error was the judge making it basically an estoppel.
Okay, all right, so stop. Fine, I understand that. That's a separate argument, right? But what you're saying is, yeah, no problem with it coming in, or you're not, right? So I want to talk about the first problem. I understand you want to say the judge did other things wrong, but the problem that we're talking about, that Judge Thacker was asking about, is it comes in, and then the parties get to have that debate in front of the jury.
And the parties are free to argue what they want and present evidence that supports their theories of the case. But here, we were cut down by the district judge when we tried to introduce...
Okay, but again, go back to the premise here. What you're saying, your response to my argument is to go to the next step. Are you agreeing that the pardon was appropriate to be entered? Had you been given the authority to address otherwise?
No, Your Honor, I don't believe that the pardon, and that's why we moved to exclude it. You have a law and order governor like Pat McCrory. Pat McCrory was very well liked in the state. When he was elected, he had bipartisan support. He was known as a law and order judge. And so you have a jury hearing that a Republican law and order governor like Pat McCrory says, well, I'm going to give these men pardons of innocence. That places the imprimatur of the chief executive of the state on the legitimacy.
The same thing happens if we introduce a conviction to prove guilt, right? So a jury has determined guilt, right? Yes, that's the whole nature of the story, right? That's what evidence is.
But, Your Honor, this was not a jury. This was an ex parte proceeding where the governor, on his own, looked at whatever he looked at and said,
Using his constitutional authority.
his constitutional authority to grant pardons of innocence on whatever terms or for whatever reasons he may deem proper according to the state constitution. There's no dispute that he had the power to do that, but that was used as basically an estoppel against us, and we were cut off and precluded and berated in front of the jury from ever suggesting otherwise. You mentioned, Your Honor,
suggest otherwise, and you aggravated the problem a lot by trying to somehow marginalize the, it seems to me if it comes in, the best way to come in would have been simply a statement by the court to say that you should know that the governor pardoned these people after a pardon of innocence and not even introduce a document. Just get that fact before the jury. But when you go and try to attack the, you can't attack a pardon because the breadth of the pardon power is so broad, it covers exactly what I said. It covers friendships, it covers acquaintances, it covers injustice, it covers all kinds of things, and it's up to the governor to decide what he wants to do on that. It's not an adjudication.
I agree it's not an adjudication, but the district court told the jury that the governor has determined as a matter of law, the district court used those words, as a matter of law that they are innocent. And that—
It would have been nicer to say they were innocent because of the MAR order.
Or something to that effect. Your Honor, we had requested a jury instruction that would at least couch this in terms of, you have heard evidence that there was a pardon. You may give that whatever effect as you see fit. We actually followed it and crafted it from an instruction given in, I believe, the Northern District of Illinois in a wrongful conviction case. That was not given. The judge at the hearing on the motion in limine in March of 2021, when he said, well, it's coming in and you're not going to be able to attack the pardon if there's any issue, and this was in his written—
Would you have been fine if the court had said they were found innocent by the MAR court?
Well, the MAR court, but the MAR court did not. The MAR court based—
So you wouldn't have been fine with that either because your theory of the case was that they weren't innocent.
My theory of the case is, Your Honor, we can talk about actual guilt, actual innocence. What we're talking about is, did they say without coercion what was in those confessions? Because if they did, then that supplied probable cause for their arrest and prosecution.
You have a lot of other
law.
issues. Are there any others that you find important before
Yes, Your
time
Honor,
runs
briefly, thank you for asking. I believe that the other major point of error in the case, if I had to rank them, was the district court's treatment of plaintiff's first witness, which was District Attorney Luther Britt. Mr. Britt was the district attorney in 2014 when the conviction—
Can you start reverse order? Can you start with telling us why, if I assume that everything you said is correct and was in error, why it was harmful?
It was harmful error.
Or why it was not harmless, that's another way of saying it.
It wasn't harmless error, Your Honor, because it infected the entire way the case was presented to the jury. The error was that they're innocent for purposes of this trial. And then their theory is innocent people confess only when they are coerced. And when you drive it and present it in that manner, the jury could logically come up—
I'm talking
with
about the
only
testimony of Britt. You were turning to talk about Britt's
was.
testimony.
All right.
But
Because—
I just hadn't heard anything about Britt's testimony. That's what I was trying to understand.
I misunderstood your question, Your Honor. Yes, with regard to Luther Britt, what was the harmful error or the reversible error? Mr. Britt, here's a man in the year 2021 testifying in a court about what he thinks may have happened, might have happened in 2 interview rooms back in the year 1983, at a time when he's a college student. He doesn't even become a lawyer until years later, doesn't become district attorney until years after that. Yet when he purports to tell the jury that referring to my clients, I don't find what they have to say credible, telling this to our jury.
Was he familiar with your clients?
He was familiar with one years later when he became district attorney, but not
But
back
prior to this trial?
prior to this trial.
Prior to this trial,
Yes,
he
Your
was
Honor.
familiar with him?
He was familiar with Ken Sneed.
And
but-
his reputation?
And his reputation years later when he became district attorney. The evidence in this case was when Ken Sneed appeared on that crime scene, he was the next to the bottom of the totem pole in terms of seniority. He was a relatively new agent. But going back to Judge Richardson's question, if I may just finish that, the error was that you have this man who the district judge vouched for. The district judge told the jury and used the words, this man, he referred to the district attorney, and this is a quote, is extremely experienced and credible. He told the jury that this man's credentials are sacred. And so he put that legitimacy on him for anything that came out of his mouth. And then that district attorney told the jury that, in that room, quote, I believe their voices would have been raised. There would have been yelling. There may have been cussing. There may have been swearing. There may have been threatening remarks made. That was pure 100% speculation. Again,
I thought that quote, I don't know, that quote or one similar to it, I looked it up, and I thought his testimony was that he had a reputation for that. And you plucked the last part out and left off the word reputation.
No. Excuse me, Your Honor. At that point, he is responding to questions from plaintiff's counsel, articulating what he thinks happened in that room just because of the nature of...
I know, but that was in regard to, he had a reputation for that.
No, what Your Honor, I believe Your Honor is referring to was testimony that was elicited by the plaintiff that Mr. Britt was aware, and obviously he wasn't even a lawyer then, but later became aware that the SBI considered Agent Sneed, one of the two agents, a closer. But again, that went to something years later.
A specialist that was brought to, quote, break in a person during the course of an interview, and that he had a reputation for that. That was part of Britt's testimony.
That was part of Britt's testimony, yes, Your Honor. But the broad statements
And he
about-
also testified, we'll have to look it up again, but he also testified similarly that his reputation was to holler and this type of thing, scream. And therefore, he concluded that's probably what happened, because
Well-
that was his reputation. But this is something we ought to check, and we'll look in the record on that.
Thank you, Your Honors. I am
Yeah.
obviously well over time. Are
Yeah.
there any further questions from the panel?
Okay, you have some rebuttal coming, and we'll...
Thank you, Your Honor.
Yeah. Ms. Stetson?
Thank you, Your Honors, and may it please the Court. My name is Kate Stetson. I represent the appellees Leon Brown and Henry McCullum. We covered just two issues in counsel's opening argument, so I'm going to restrict my response to those two issues unless the Court has other questions on
I
other
do have
issues.
a couple of questions for you, but why don't
Sure.
you lead off?
Certainly. And I'd like to start, actually, Judge Richardson and Judge Niemeyer, with the colloquies you were having with counsel about the admission of the pardon. And I want to try to untangle a couple different lines of questioning there. You asked, of course, about the admission of the pardon in the first instance, Judge Richardson. And then there's the question about the use of the pardon or the effect of the pardon at trial. The admission of the pardon, as you pointed out, Judge Richardson, is completely within the district court's discretion, particularly when, as all of the cases that either of these parties have been able to find point out, the defendants are still contesting guilt. That's Hill, that's Howard, that's Sanford versus Russell, which also points out that the Seventh Circuit
Yeah, but see,
actually...
the problem with that is they may still be contesting guilt, but you have the benefit of an MAR saying that the evidence was insufficient. The determination by the governor to pardon is not a determination of guilt. It is a pardon of innocence, and it is done for any reason that the governor can think of. And he makes a totally discretionary decision. My biggest problem is why was that introduced, and why did you guys want to press it? You had a lot going for you, And the problem for me is not that it was just introduced. It came up again and again during the trial. And the jury were constantly told the governor declared him to be innocent. We can't challenge that. Well, what does the jury try to figure out what that means?
So Judge Niemeyer, let me start by just pressing back a little bit on this idea that the governor can pardon and issue a pardon of innocence for any reason he wants. He can't. He issues a pardon of innocence because he has concluded, based on the entire record, that the people before him are innocent. That's why these two plaintiffs were entitled to statutory compensation. That's the prerequisite. But to get to your subsequent question,
Well, that's the nature of the pardon. But what he goes through and why he does it is unimpeachable. And there's no trial. He doesn't adjudicate that. We have courts for that, and the court did adjudicate that. And the question is, that's not even an element of your claims in this case. The element is the fact that the evidence turned out to be insufficient, and that was an adjudicatory process.
No, Judge Niemeyer, the instruction that the court gave the jury at page 1912 of the joint appendix was that the governor had issued a pardon of innocence. That was an instruction that was unobjected to by the defendants. But more to the point, the reason that this kept coming up at trial goes to your question, Judge Thacker, about the theory the defendants were pressing at trial. The defendants were pressing a major theory at trial that they said over and over again. This is Joint Appendix 1015 and 1016, the opening arguments. These defendants confessed. They confessed over and over and over again. And boy, did they get that into the trial. Just the video alone of Henry McCullum confessing was shown at, and I apologize for the litany, Joint Appendix 1019, 1020, 1104, 1108, 1251, 1335, played for the jury while cross-examining Henry, 1672, 1881, 1931. That was their theory, was that these defendants had confessed. But further to that, Judge Thacker, you started by pointing out that Mr. McClatchy had started his argument by saying something that this court also said in its first opinion. What happened in the interrogation room is at the heart of this case. And the opening brief of appellants said the same thing at page 3. The reply brief says the same.
You have also the strong evidence you actually put on the plaintiffs, and
Yes.
they testified. And the jury is clearly entitled to make that determination as to what happened. It's the question in my mind when I raised this pardon question, because I personally haven't come across that since I've been on the court, of having a pardon introduced as evidence in a case. And that wouldn't be so bad in my mind, except how it was used in the case. And maybe that's all right because it's parallel to the MAR, but that's where my questions were.
Sure.
I do have a question totally different that has not been argued, but I'm going to ask you about this prejudgment interest, $36 million. Prejudgment interest is compensatory, right? It's for the loss of use of money.
Yes, it's equitable and compensatory, yes.
And why is it equitable? Loss of use of money, interest is not an equitable. It's treated in some cases by the discretion of the judge to add afterwards, and that's what I want to get to with you. But it's for the loss of use of money, which is a totally pecuniary computation. And the most traditional notion is when somebody sues on a note and the jury gives back the payment of the note but doesn't include the interest, the court can add the interest. That's the traditional method when there's a liquidated amount. In torts, the whole discussion is much broader. But my question is a little bit more fundamental than that. Here we have a jury that's given a very broad instruction on damages. I've read the instruction a couple times. And the jury can give compensation for just about anything, including monetary, pain and suffering, loss, all these things. And the judge said it's for you to determine. Well, the jury comes up and determines $31 million for each plaintiff and says that's our number. The court comes in and adds $36 million in compensatory damages. And he's given it for interest, pre-judgment interest, which is a computational notion. How do we justify a court coming in and adding to a jury's verdict?
A couple responses, Judge Niemeyer. The first is, you'll recall...
You can start with the constitutional issue, but you can go anywhere. I mean, the jury trial right.
I'd like to start with the waiver issue, actually. These defendants did not raise this issue below, and the fact that
they challenged the prejudgment interest.
they challenged the interest. They didn't say this should have gone to the jury, and that's a flat waiver. So, but to your constitutional question, you know, what this court has never held that a judge cannot compute prejudgment interest. And in fact, we point out the Supreme Court in Osterneck held, with respect to a jury trial, that it was sufficient for a judge to compute prejudgment interest, precisely because it is equitable. And to your point, Judge, about the $36 versus $31 million.
How can it be equitable? Prejudgment interest was awarded at 8%. That's computational. And prejudgment interest is a compensatory damage. And the jury was given a full blow on what compensatory damages it could award, and it chose $31 million. And the question now is the judge adds another $36 million, well, $18 million person, to the verdict. And he does it without any money owed back then. The money wasn't owed until judgment, and the determination of the amount wasn't owed. I mean, these are all fundamental questions. You can cite cases where judges have blurred this type of thing, but the whole notion is we have juries to make award compensatory damages, and it's not equitable, it's computational.
Right. So I think
if somebody calls it equitable, they're just wrong.
It has been called equitable, and I think there's really not a dividing line between equitable and computational. But to your underlying question, I think there is, if there's an academic debate out there, particularly in the First Circuit, not in the Fourth Circuit. All of the cases that defendants cite, of course, are in the First Circuit Court of Appeals. If there's an academic debate, this is not the case to resolve it, where this issue was not presented to the district court.
50% addition to a jury verdict based on compensatory damages?
Yes.
This is not punitive. This is not post-judgment interest. This is just adding to the compensatory damages, which were already quite large.
And they were quite large because what the jury awarded was $31 million for every year that these two men spent wrongfully in prison. So the $36 million, that is a large number. We stipulate.
Can I ask a question on the premise you said? You said, and I take your point, that your argument is it wasn't argued below. And what I'm curious about is the argument that's made in their opposition at page 8, where they seem to be making Judge Niemeyer's argument, right? That there was no allegation or finding that the defendants unlawfully deprived the plaintiffs of the use of any money due to them, right? This is the idea that we naturally think of prejudgment interest in like a contract action where there's a determinate amount of money and they're depriving them. That seems to be the argument that Judge Niemeyer's making. Why, I mean, I get we can slice it super thin, right? He doesn't use the exact words, but that seems close, no?
No, well, number one, I think there's the principle that this court has endorsed before, that a judge doesn't need to kind of pore over a defendant's pleadings looking for an argument that wasn't preserved. But Judge Richardson, that argument
it's on page 8, right?
That argument on page 8 was made with respect to the idea that they did preserve below, which is that you cannot award, full stop, pain and suffering damages, prejudgment interest on pain and suffering damages. That was their argument. The money that they were owed has to do with that reducible sum, the note that you were talking about, Judge Niemeyer. That's another argument.
That's just merely the lack of a citation. The fact is they're basically saying you can't add to the jury's verdict. The jury is a jury. It's an institution, and the award of damages, compensatory damages, is committed to the jury. The judge has equitable remedies he can add, but money damages are committed to the jury, and we agree that this was money damages. Not only was it money damages, it was over 50% addition to the money damages, which is extraordinary in view of the fact we have this sort of non-economic award of damages in the sense that it's related to pain and suffering and all the other things the judge I mean, the judge went on and on about the damages. Fair and compensation, you can do it for expenses of the plaintiff, you do it pain, suffering, mental anguish, shock, discomfort, other physical ailments. All of this, the judge is telling the jury to do it. Not only that, the judge tells them you have to, with respect to the settlement, you have to award all the damages. I'll take care of the rest. In other words, you find out how much the persons were injured, the plaintiffs were injured, and give the full award for that, and then I'll take care of adjusting for settlements with respect to that award. And that's what the court actually instructed the jury. And so the jury gives its full award for the tort, and then the court refuses to take off $11.5 million, which they already received with respect to that same injury.
So Judge Niemeyer, you're moving to the set-off. May I make one?
I'm talking about
Yes.
instructions to the jury, actually, and I bled into that.
Okay, but what
my
one?
biggest problem in this case is what I call this piling on with the $36 million of compensatory damages added by the judge, and then not giving them, the plaintiffs, the benefit of monies paid with respect to this very same injury.
Okay,
by
so
others.
let me just make one more point, if I could, on the prejudgment interest. I'm happy to turn to
Yeah,
the
sure,
set-off.
of
Neither
course.
of these
No.
was the focus of the argument, but we
Fair
can
enough.
certainly turn to it. With respect to prejudgment interest, you've mentioned a couple times, Your Honor, the $36 million. The $36 million was because these two plaintiffs waited for 38 years for someone to recognize the harm that they suffered, the pain and suffering that they
understand,
suffered
but
from
see,
being
now
on death
that-
row for 30 years.
You're just launching into what is exactly wrong with the problem. In other words, it's the loss of use of money, but there was no determination that they were entitled to any money back then. The determination wasn't made until the jury said they were entitled to it. Whereas normally prejudgment interest attaches to where there is a known amount in the past that's payable, and the jury verifies that, and the judge then gives the interest. And
So
so
I
I know
take
there are cases that awarded on torts, but I'm just
Sure.
telling you that that is conceptually a problem when we're separating court from jury.
Sure, and just one more point on that, and then I'm happy to turn to set-off. The harm has to be known at the time. When you talk about a known amount, the harm has to be known at the time. It's not determined. No jury, unfortunately, determined that these two men were innocent in 1983. It's the harm that accrued that forms the basis of the pain and suffering that leads to the prejudgment interest. But I understand your point.
Interest is a sum added to an amount,
It is.
and there
It
was
is.
no amount that was existed back then.
It was the amount
And
the
the
jury
ultimate amount
determined.
could have been 10 million, or it could have been 3 million.
It was amount the jury determined. That argument was not preserved below, and the court appropriately, in its
So they
discretion, ordered
objected to it. They
prejudgment
didn't
interest.
label it jury versus court. But that's about what you're arguing when you say the judge shouldn't have imposed.
I think to the extent they tried to quasi-preserve it along the lines that Judge Richardson pointed out, I think this is probably not the case to try to indulge in the question about when a judge can or can't award
Why isn't
prejudgment
this a case?
interest.
This is an extreme case, interest on the amount you determine to also if you want.
Mm-hmm.
Now, the court didn't say that, but the court basically said you can award any amount that you determine is just and appropriate. And it seems to me, if you argued that they should be given interest to the jury, they would listen to you.
Your Honor,
You didn't make the argument, but
I take your point, and we could write law review articles about this. My point is that because this issue hasn't been decided by the Fourth Circuit, it would be better to wait for a case where this issue was actually preserved and fully aired below. But on the set-off point, let me make just a
it's
couple.
not a set-off. It's not a set-off.
Not a set-off.
No, it is the notion that for an injury, you get one satisfaction. That's the law.
And
the one satisfaction can be given by many people or one person. And then, of course, joint tortfeasors can make claims among each other. But in this case, the court explicitly told the jury, don't worry about the settlement, award the full amount of injury and damage. And I'll take the rest.
Sure. So Judge Niemeyer, we don't need to debate the label. The label really isn't important. What's important is that this was filed as a Rule 59E motion. And particularly with respect to 2 of the 3 items that the defendants are now claiming should have been set off, they were present from the very beginning. And Rule 59E, as this court has said repeatedly, is deserving of only those instances where something could not have been raised
Except
before judgment was
The court
entered.
added it, right? The court refused to deduct it when it entered judgment. In other words, it wouldn't come up until later because the court appropriately said to the jury, you find the full award and I'll take care of we'll call it a set-off, the set-off, and that's what the court told the jury. And then the court awards the full judgment and doesn't do it. Now, how did they object to a judgment entered in that fashion before the judgment's entered?
They could have done it in a number of ways. With respect to the Red Springs settlement and the statutory compensation, which, by the way, is for a completely different type of harm, they could have done it at any stage of the proceedings, motions in limine, the answer to the complaint, any time before trial. And during trial, they could have said, before this court entered judgment, after the jury delivered its verdict, after the jury was dismissed, after final proceedings were wrapped up, they could have said, by the way, Your Honor, we would like a set-off not only for the Red Springs and statutory settlements that occurred years ago, but for the settlement that just occurred last night. We would like that set-off. We are now moving for it. They cannot wait for 30 days until Rule 59E kicks in and then file a Rule 59E motion saying, by the way, this is new stuff. It's not new stuff. They should have argued it right from the beginning, and they did not. So that's, again, another waiver.
Can I transition back to an issue that causes me some consternation and give you a minute to talk about it?
Certainly.
And this is the testimony of Mr. Britt. And in particular, he testifies as a lay witness. You lay, and I don't mean you personally, but you lay no foundation for why his information from 1989 forward relates back to 1983. It might. I'm not saying you couldn't have laid a foundation, but to lay that foundation, he would have had to testify as an expert. And then, which he didn't, obviously, because that would be applying non-firsthand information, right? He's sort of speculating about what happened. And then you come back on the back end and ask him the question that you can never ask, right? Does the defendant's description of what happened, do you find it credible? And with no sort of foundation for how he knows that, but also in direct contravention of the idea that we don't ask one witness if another witness is lying or not credible. And so I'm having a little bit of a trouble. And then, obviously the judge comes back later in a different context and says, this guy's really credible. Help me understand why that's not a harmful error, given, as you sort of said earlier, what happened in the interrogation room is at the heart of the case. This is the case. And he says, no, in 1983, when I wasn't there, and I'm not an expert, but I'm really credible, I know that these defendants are liars.
I see my time is up, Judge Richardson.
Yeah,
Can I respond to your
Please,
question?
please.
So just to start with that last point, the cases that talk about an expert witness getting on the stand solely to say that witness is a psychopath and he must be lying, that's not this case. What this witness said was, I don't think that description, no yelling, no threats, no screaming, no cursing, no promises, I don't think that description is credible. But in addition,
But
what
it's
we're
not just
talking about—
experts that can't say a witness is credible. And we have tons of cases saying that a witness, expert or non-expert, cannot say that that witness is a liar, right? That's the province of the jury. The jury gets to determine that. You could have asked a question that gets to the point, but you asked the question, are they credible? And that's what you can't do, particularly with no foundation for it.
I think it is slicing it a little differently to say, do you find Mr. Sneed credible? What they said was this description, do you find it credible? But your question was about error and whether it was harmful. And my answer is no, for the reasons that we point out in the brief. There were multiple other instances where exactly this same testimony came in. Joint Appendix 1177, Joint Appendix 1424, Joint Appendix 1283, and Mr. Britt's own testimony at Joint Appendix 1081 to 83 saying, in my experience, I've been the district attorney for 30 years. I know Robeson County practices in the 1980s.
Right, but he's saying that in response to 1080, where the question is, do you find the defendant's description of the interrogations credible? That he's giving the answer to the very question that's not permitted. right?
this-
I mean,
this
that's
co-
the end of that day, and then at 1091, they come back and ask the same question again. I mean, it's like, it's a little remarkable to me that they ask the question, do you find the defendant's testimony credible? I mean, that's like a golden rule, like, don't ask a witness that question, right?
Your Honor, and you know, the harmless error point that you made, I think, kicks in here. To the extent that it was not a well-phrased question, number one, the jury was instructed, of course, that it has the job, twice, I think, that it has the job of finding whether these witnesses are credible. But also, when you talk about an error that's committed in the course of the trial, you look at what else came in that could have assuaged that error. You have to ask, as this court said, is there fair assurance that this thing substantially changed the outcome of the trial? That's the harmless error standard.
But the other evidence you gave me is all Britt's testimony. So the point is, this is Britt. So what is, other than Britt, who said that in the jury, and the plaintiffs, did anybody else say that what went on in the jury room was yelling, screaming, and intimidation?
Those were the appendix sites that I read you. So Mr. McCrary, on direct examination at Joint Appendix 1177, talked about the details of the confession and how unlikely it was in the extreme that these defendants actually said the details that were in the confession. Ken Rose, Joint Appendix 1424, same thing. Dr. Leo, Joint Appendix 1283, talking about the time that had been consumed at the confession. The bottom line question, as we've been discussing, is what happened in the room? And many witnesses, not just Mr. Britt and not just on that one thing that he said, many witnesses testified that what happened in that room had to have been something other than what these defendants said it was, which was just a conversation like we were talking to one of our sons.
Let me ask you something. There's a little bit of a takeoff on that, and I know we're over time, but I'm interested in your position on this. The theory, as everybody seems to agree, is what happened in that room. And the theory of the defendants in this case is that they were confessing the plaintiffs in this case, the defendants there, were confessing to real guilt, that they were actually guilty, they were confessing to that guilt, and tried to demonstrate that they were guilty at that time in order to verify the confessions they were giving. And goes to the heart of what's, that they were forced confessions.
Yes.
Is it appropriate to have a pardon come in and say, that theory's no good because the governor said they're innocent?
Judge Niemeyer, I think it was fully appropriate for the pardon to come in for exactly the reason that Judge Richardson said. This is evidence bearing on the question. If these defendants, as the courts in Hill and Sanford and Howard all said, if these defendants had been prepared to say, we concede that the governor's pardon of innocence applies here, then it just would have been an element of the instruction, and maybe the whole case wouldn't have turned into the sideshow about guilt or innocence that it did. But these defendants were not prepared to concede that. They made guilt an issue, and because they made guilt an issue—
Because we're talking about a confession that's made up and fabricated, which is your allegation, or a confession that represents the true facts.
They did
and
not
they're arguing that the confession represented the true facts. That's their argument. And they're saying the governor has no say in that. The jury has the say in that. And I would think the MAR court could come in. That's an element of the offense. MAR defense is saying the evidence was insufficient. But I'm toying with the question of whether this was just a harmless problem or whether it went to the heart of the defense. And I genuinely don't know the answer to that, and that's why I'm exploring it with you.
Sure. I think, Judge Niemeyer, the answer is it's a problem of the defendant's own making. There were many ways that the defendants could have tried this case.
No, I know,
and
but they objected to I'm talking about the pardon.
Yes.
The pardon's what, the pardon interjects and says an element of their defense was that they signed a confession that was consistent with actual guilt.
Yes.
And therefore, there was that was part of their defense. And there was no fabrication. The jury is told, no, they're innocent, because the governor said so. And yet, they are not entitled to go behind that. And that's a collateral proceeding. And I'd be happy to hear you, but I'm just having some trouble with that.
But-
And maybe it's all just harmless, I don't know.
So I think it is indeed harmless for this reason, that these defendants, you will look in vain in either of their briefs for any evidence or testimony that they were precluded from putting in, other than what the district court found in his discretion was zero evidence that these pardons of innocence had been procured by fraud. So what you are left with is a defense
That isn't my
strategy.
problem. My problem is the evidentiary effect. The court kept
Yes.
telling the jury the man is innocent.
Yes.
And
So-
which takes away their defense to say the confessions were consistent with their guilt.
It does not take away that defense about their confessions. In fact, that was part of the litany of joint appendix sites that I read you earlier. If you look through the transcript, and I encourage you, of course, to read the whole transcript because you look at the case as a whole, you will find event after event after event after event of these defendants cross-examining every witness about the fact that Henry purportedly repeatedly confessed to the crime that we're talking about. They had no trouble putting on evidence about the confessions.
And the idea was there's evidence of coercion. You have a strong case on all those. But their defense was that this was not, and one of your big points is that the confessions were fabricated, that
Yes.
they made up evidence of their guilt. And in order to make them guilty, they made them sign it. That still may be good, but the point is they were arguing that the confessions were not fabricated but consistent with guilt. And the court interposes and says they were innocent, and because the governor so pronounced, and we can't impeach that. And so the question is that element of their defense is taken away, isn't it?
Your Honor, what the court said repeatedly, except for one occasion, which I will get to, what the court said repeatedly is that the governor has declared them innocent. They have pardons of
The court went
innocence.
further. He says they are innocent. I mean, the court
And
lost
that's-
its
and that's-
cool several times and said they are innocent.
One time, he said they are innocent for purposes of this trial, and that was immediately following explaining to the jury that the governor had pardoned them.
Right,
So
right.
just to Judge Richardson's question, just as they were fully able, over our objections, to put in lots of evidence consistent with the guilt, the confessions to Floyd, to Sultan, to the sister,
They're all
to the mother.
overcome with the court's instruction.
That is not correct, Your Honor. The court's instruction to the jury was the governor
are
has issued them pardons of innocence. That was the court's instruction to
No,
the
I'm
jury.
not talking about the instructions at the end. During the course of the trial, the court repeatedly said they are innocent, and we can't go behind that.
Your
And
Honor,
so the
I'm-
question is, that element is gone. Now, the question is whether that's meaningful. I don't know if fabrication is the biggest part. Duress is, you had a very strong case on that, too.
We did.
Anyway, we've gone over, and
So, Judge, if I could just respond on that last point, what happened in the room is at the point of the trial, is the point of this
course,
trial.
yeah.
What happened in the jury room is that the jury concluded that these confessions were coerced and fabricated from two intellectually disabled teenage boys. That jury verdict in this civil case should be upheld. This court has never in 50 years reversed a jury verdict in a civil case for what we're talking about. Thank you, Your Honors.
thank you very much. All right, who do we hear from next? Mr. Peoples, is that it?
Good morning, Your Honor. Good morning, Your Honors, and may it please the court. My name is Adam Peoples, and along with co-counsel, I represent defendants Allen and the estate of defendant Sneed. I'd like to begin, Your Honors, if I may, and perhaps that's all I'll get to, but I think it is the heart of this appeal, and that is, were these errors harmful? Judge Richardson, you asked that question. Judge Niemeyer, you were very interested in that question most recently. If the court will permit me a brief statement, I had the privilege of being trained by a very good trial lawyer, and he taught me two things, both of which bear upon the trial and the errors at issue in this case. The first of which is that you leave nothing to chance. When I go to trial, I wear a white shirt, I wear Continental colors, I don't have a bottle of water on my table.
What colors do you represent?
Continental colors, red, blue, and dark colors,
yeah.
just like that. We don't leave anything to chance. We don't want the jury to think we have bottles of water if they don't have bottles of water. And so, Your Honors, when the court below said what it said of us, I was absolutely horrified. The record doesn't adequately convey to your honors, reading it on paper, what happened in that courtroom, but I was there. And the judge pointed us and he said, they, of the defendant, think he ought to be executed. Now, if I'm worried about what color tie I'm wearing, that statement from the court in front of the jury about us was mind-boggling. Your honors asked, why is this harmful? That's why it's harmful. Because the court didn't just make interjections. He didn't interrupt us equally. The court made statements about us, about our clients, about the defendants and defense counsel.
Yeah, I understand that, and those points are all well taken. And there, as you know, there are no perfect trials, no perfect judges, and we basically are reviewing this to see whether there is need for a redo or not. And so we really have to assess the scope and impact of any errors that may have come about. The plaintiffs in this case put on a lot of evidence as to what went on in those rooms and a lot of collateral evidence as to whether what was in those confessions was true. And that evidence is pretty powerful, I think, apparently for the jury. It seems to me, and I'm just sharing this with you, it seems to me the question that we have to resolve is whether that powerful evidence is overcome by the errors that you have pointed out in your briefs, and that is a little bit of a crystal ball type of assessment, because you have to figure out whether the jury would have done the same thing without that. So I think that's where we are on. At least that's where I am on here. I think there were some things that maybe shouldn't have happened, and what you're commenting, judicial demeanor, is something we can't see. You experience, we know it happens, and judges often share their views of cases in a very subtle way sometimes, but our assessment has to trust the system to some extent until there is sufficient evidence to show that a redo is necessary.
Well, that brings me to my other point, Your Honor, but if I may, before I get there, just to finish the thought, and it's a review of all the record that would deliver this information to Your Honors, but 3 times the judge told the jury that the plaintiffs were innocent. 3 times the judge told the jury that we were accusing these innocent men of being rapists and murderers, and at least on one occasion that they ought to be executed. Your Honor, at that point in time, the jury couldn't help but align itself with the man in the black robe and the plaintiffs. At that point, it became them versus us. That's not the way it should have been. It should have been plaintiffs versus defendants. But to Your Honor's other point, that is the court's management of the trial, Mr. Britt's testimony also goes to the heart of that issue, and that is the second point that I'd like to address with Your Honor. As to the second thing I learned about trying cases, credibility is everything. My mentor used to say, the first liar loses. And going into this trial, we felt pretty good about our chances. Our clients had consistently told the exact same story from beginning to end, from 1983 all the way until the day they were tried. The plaintiffs, on the other hand, have offered contrasting accounts. It is undisputed that they signed written confessions to committing the crimes. It is also undisputed that Mr. McCollum told a news reporter later, outside of the environment of any coercive interrogation tactics, that he did in fact do the thing of which he was accused. And so going into it, it was going to be a credibility determination it was going to be a credibility determination of he said, she said, the defendants versus the plaintiffs, what was going to happen.
Did the judge instruct the jury that they're the sole arbiters of credibility?
He did, but that was after, and thank you, Your Honor.
More than once?
He did, but he also told the jury, if I may read, this is at the record on 1106, this is regarding Mr. Britt's cross-examination. He said, I don't think he's impeaching him, meaning Mr. Morgan is impeaching Mr. Britt. I think the district attorney is, quote, extremely experienced and credible, close quote. He can take care of himself. Later on, he says, Mr. Britt is one of the most renowned district attorneys in America. And on the next page, I'm reading from 1106-07, and this is it. He says, Just for the record, you couldn't find anybody whose credentials are more sacred than Mr. Britt's. Going on to the next line, this is the judge. I know that. I've been on this bench 37 plus years as a judge. What good does telling the jury, what good does it do to tell a jury, you decide credibility, when the judge himself has said, I know from 37 years.
Did the judge also give that instruction, or that is ordinarily given about nothing that the judge says or during the course of the trial is evidence or to be considered by you in your deliberations?
I'm sorry, Your Honor, I don't know the answer to that question.
I bet he did.
I do know that the question.
Do you think, can I ask a different version of this? If the plaintiff's lawyer had said that in closing, would we consider that, vouching and improper? So if the plaintiff's lawyer had said, Mr. Britt is extremely credible, his record is unimpeachable, and he's a man of the first order, would that, we often have some kind of discussion like that by lawyers, and I get this isn't a lawyer, it's a judge, but do you think it would have been a problem if the plaintiff's lawyer had said the same thing the judge said?
I do, but to Judge Niemeyer's point, that takes us beyond the crystal ball. There, we're probably in the crystal ball domain of, is this really harmful or not? When the judge says it, there is, and with all due respect, Your Honors, no way that we can have fair assurance that my clients were given the fair trial they're entitled to have. That was so prejudicial, Your Honors, that we asked that the judgment be reversed, that we be given a new trial, and that the case be reassigned.
Thank you.
If there are no further questions, Your Honors.
All right, I think that concludes the evidence. We would normally come down and greet you. This is a tradition of the Fourth Circuit. Judge Parker introduced this in the 1930s. I don't think there's any other court that does it. It's our iconic gesture that this process is still a civilized process where we can all shake hands, and we'd love to do it, but we're still observing the protocols of COVID. So we will just have to greet you from the bench and thank you for your arguments and proceed on to the next case.
Your Honor.
Manufacturing, and Mr. Gebhardt, whenever you're ready, we'll hear from you.
Your Honor. Lawrence Gebhardt on behalf of the appellant Biobarrica, Nebraska. Your Honors, the focal issue to be decided in this appeal is very simple. Did the payment terms in the original Biobarrica, Nebraska invoice sent with the initial delivery of the first installment of product and requiring payment of delinquency interest and collection costs become part of the contract between Biobarrica, Spain, the parent company, and Nutramax for the purchase and sale of the chondroitin sulfate? As a matter of undisputed fact and clear law, the payment terms became part of the contract under UCC 2, Section 207 per N1. The invoice accompanying delivery of the initial installment of products was a conditional acceptance of the purchase order that it was accepted by Nutramax in accordance with the invoice's term.
Let me ask you what the issues are. There's been a lot of fluctuation in theories on this case, and even on appeal. I thought on appeal the two issues we have before us, or maybe one issue, is novation, and the other is assignment of the contract. Now, tell me what the issue is on appeal, what's been preserved for argument on appeal.
Yes, what's been preserved was the summary judgment issue of whether the invoice accompanying the initial shipment, and it is undisputed that the invoice accompanied the initial shipment, rejecting the terms of the purchase order and substituting its own and putting in a procedure.
I thought your argument was, I must say, I thought your argument was that, number one, the contract had been assigned from Bio, Spain to Bio, Nebraska.
No, Your Honor.
And that there was, second, there was a novation which Bio, Nebraska's contract interposed for Bio, Spain.
That argument arose out of a mistake of which invoice was the initial invoice. Bioberica Spain is the parent company, and it used Bioberica Nebraska as its billing and collection agent in the United States, and then it would bill Bioberica Nebraska for what Bioberica Nebraska collected. When this was sent for collection, the invoice between Bioberica Spain and Bioberica Nebraska for the delivery to Nutramax was sent to counsel. It had no payment terms. It was different than the succeeding invoices. We didn't discover the actual invoice that was sent to Nutramax until all the documents in.
Which you're saying was the heart of your case.
Yes, there was no novation.
And yet you filed a complaint on something totally different. You didn't find this until 2 years into your case on your fourth try at the complaint, correct?
The documents came from Spain. They had an invoice that had no payment terms, and there was
But
paid.
you did file a complaint and then didn't have the key piece of your, what you now say is your case, until 2 years after you filed the complaint, correct?
Ultimately, chronologically, yes.
And until you filed 3 amended complaints and tried to file a fourth, correct?
The novation was a mistake. It could not possibly happen. It was not there. There was
Isn't
no.
the novation and the, well, and your client's decision to ignore the novation, isn't that the basis upon which the district court entered summary judgment?
No, the district court said, I denied your motion to file a Fourth Amendment complaint.
The district court said, Bioberica Nebraska's decision to entirely ignore novation in favor of an inappropriate attempt to revive claims this court already rejected is sufficient grounds to deny its motion outright, since it proffers no affirmative summary judgment argument as to the sole operative claim in this case. So
Yes.
where is the basis for that dismissal addressed in your briefing here?
Yes, because the district court then said, but we're going to address the merits of the summary judgment arguments, namely what the real invoice was and whether that was an acceptance or a rejection. The district court de facto reversed the denial of the the filing of the Fourth Amended complaint.
I'm sorry, say that again, because I thought I heard something, but that doesn't
Yes.
seem like it's right. Say it one
The
more time.
district court denied the filing of the Fourth Amended complaint to add the newly discovered invoice. But the district court said in its summary judgment ruling, while we refuse to permit the Fourth Amendment complaint to be filed, we're going to address the merits of the issue it raised to clarify everything. And they then got to the substance of what was set forth in the Fourth Amended complaint and made a fundamental error of law by saying that the initial invoice from Bioberica, Nebraska was sent 2 weeks after the initial
But
delivery.
what you said was something different. So that, I understand that argument. What you said is it de facto reversed its prior procedural ruling.
Yes, the district court did not stand up and say, we're not addressing Bioberica, Nebraska's summary judgment argument because we denied the right to file the Fourth Amended complaint and let it go there. The district court said, but we're going to address the merits of your summary judgment
It said
argument.
both, right? Because
Yes.
Judge Thacker just read, you lose procedurally, and then it says, even so, you lose substantively.
Well, under Rule 15b2, the district court must accept and must consider the complaint amended if, to conform to the evidence that's presented in summary judgment, if there's no objection by the other side and the evidence comes in.
There was an objection, though. You
No, there-
lost. Like,
no,
you
there
tried to do it, and you lost. I don't even understand the argument, frankly.
Nutramax introduced the original exhibit, the Bio-Barrica, Nebraska exhibit from January of 2018, and said this invoice and the initial installment of product were delivered on the same day. We introduced those same exhibits, and they said we have no objection to it. It's the same as if you went into trial and you put your evidence on, and the court admitted it over no objection from the other side, you must rule on the merits under Rule 15.
Mr. Kemper, we're trying to get to the issue in the case that's before us, and you're doing the same thing that you did to the district court that frustrated the district court, I believe. I'm looking at your third amended complaint, which is the subject matter of this cause of action and this appeal, right?
No. The subject matter of this appeal is the summary judgment motions that introduced evidence
Just a minute.
that went beyond.
I'm going back before the summary judgment. Let's disregard how it was handled. I'm going back to your claim. The operative complaint at this point, unless we say the court was wrong in denying your fourth amended complaint, the third amended complaint is the operative complaint in this case, right?
No.
What is the operative complaint?
The operative complaint is whatever is needed to reconcile the evidence that was introduced and upon which the summary judgment rulings were based
I
under
thought I was asking you a
15b2.
very simple, straightforward question. There is no fourth amendment complaint at this point. The court denied it.
Yes.
You'd have to reverse. So the third amended complaint is the last complaint on which you filed.
But that was superseded by the evidence presented at trial, meaning the summary judgment arguments. 15b2 says that.
Is
Well,
that
why
why
don't
you
you start
say
with
it was?
and concede that that's a complaint? I mean, the point is you've sued for, number one, novation. That's on page 277. And then alternatively, assignment and modification. Those were the two grounds that you alleged in your complaint. And those two grounds were rejected by the district court.
One of the grounds was rejected, the assignment. The novation was permitted to go forward, but you could not prove novation. I couldn't come
The
before
court permitted novation to go forward?
Yes.
Tell me, where's that?
the third amended complaint.
That's what you alleged. I'm asking you what the court permitted. You said it was permitted to go ahead.
She permitted, the third amended complaint stood. She permitted the novation claim in the third amended complaint
And she
to
denied
proceed.
the novation, right?
At the summary judgment
Yes.
hearing. Yes.
Okay, that's the issue that's before us.
Because you can't, Your Honor, if I put in my.
Just answer my question.
No,
The
we didn't.
question is, you filed a complaint, number one, that had novation, alternatively assignment. The district court granted summary judgment on novation against you.
They granted summary judgment on UCC 207 because delivery was supposed to have been done before the invoice issued. That was ruled on in the summary judgment pleadings, in the summary judgment
That was an
ruling.
alternative ruling based on the fact that the Fourth Amendment complaint, if the court were wrong.
You can't,
We got to start with what you are going to the court and pleading. You filed, the third amended complaint is the operative complaint in this case at this point. On the third amended complaint, you made two claims, novation and assignment, alternatively assignment. The district court granted summary judgment on the novation claim, and with respect to your effort to file a fourth amended complaint, it denied it.
and that's what the error was.
Okay, you can argue that it was an error not to grant that motion, but you can't argue that's the case now. What's the case before us, the disposition before us, is that you did not demonstrate a novation.
Your Honor, you can't, if I had put in my brief that today is Monday, could I come here in oral argument and say it's not Tuesday? The novation factually was incorrect when the evidence came forward and the original invoice was produced and the checks paying it. You can't argue, you don't go in front of the court when you have a fact that you know is
So then the court was
wrong.
right to grant summary judgment on novation?
No, the court,
I
the
thought you
courts.
just said you
You just
can't
said so.
The
prove
court said,
novation.
the court said the original installment was delivered on January 4 and the invoice sent on January 18. In fact, they were both delivered together as Nutramax put in its summary judgment pleadings, as the evidence, the invoice and the checks paying it also established, and the district court addressed that argument on the merits that had nothing to do with a novation. She didn't discuss novation.
That's your fourth amended complaint, right?
The fourth amended complaint raised that, yes. But she didn't deny, because she denied the fourth amended complaint, did not mean that at trial you couldn't raise the issue and
We're
introduce the
talking about
evidence.
5 complaints in this case. 5 complaints.
No,
The third amended complaint was the fourth.
there was a complaint that had to be amended because
I don't care the reason. I'm saying there have been 5 complaints advanced by you in this case.
no, there's the fourth amendment was the last one, and that wasn't permitted.
Is there any limit on your idea? I mean, I understand, I think what I understand you to say is, if the district court denies it, your motion to amend, you can just show up and hand the evidence over, and the court has to consider it. Is there any limit to that? I mean,
Yes.
because that just means you can never deny a
No, no, no.
motion to amend.
There is a limit. If we introduce the real invoice and the checks paying it, Nutramax at that point could say, we object, this is not relevant to the novation claim. The district court could say, I sustain the objection, and that ends it. But they didn't do that. They said, we have no objection to the introduction of those 2 exhibits, and then they, in their own summary judgment motion, introduced the same 2 under Rule 15b2.
For purposes of the claims that were before the court, not for the purpose of claims that have been rejected by the court already.
The claims before the claims before the court are what the evidence showed. The evidence that went before the court, even if not within the boundaries of the third amended complaint, constituted the grounds for the summary judgment. The Eighth Circuit in American Farm Mutual v. Hollander, 705 Fed 3rd 339 said, thus, a district court's refusal to permit an amendment before trial does not prevent the court from allowing the amendment if the issue was subsequently tried by the parties' consent. That issue was tried because Nutramax consented to our introduction of the exhibits, and they introduced the exhibits. The district court addressed the claim on the merits, and that essentially de facto amended the complaint under 15b2.
Setting aside the amended complaint, the court denied it, and denied it for 2 reasons, but denied it. The court granted summary judgment otherwise. Did the court commit error on the other ruling?
Granting summary judgment, yes, because the court said that payment terms of the initial invoice did not become part of the contract because the initial
I thought
invoice.
the court addressed novation, and there was no evidence of a novation.
Well, we didn't try to prove novation. Yes, that was absolutely correct. There was no evidence of novation. I didn't try to go into the court and say.
The operative complaint, you say you didn't prove it. That means you lose because you alleged your number 1 allegation in the third amended complaint is novation. Your number 2 allegation, alternatively, assignment. Now, if you didn't prove the novation, the court was correct.
No, under 15b2, the court was incorrect. The federal rules say must consider it amended, not may, not if it decides to, uses the word must.
My question is, did even the evidence you introduced, did that demonstrate a novation?
We candidly said from the beginning in the motions for summary judgment, we are not arguing novation. Novation is now moot. It's no longer before the court. There was no reason, I mean, I don't think that, addressing the requirements for a novation was an argument that had no basis. We didn't argue it. We didn't present any evidence of it. We said it is not here. It was,
Does that
again,
mean your complaint was frivolous?
no. What
You
was
alleged novation.
What
You
was
just said
frivolous
novation had
was-
no basis.
What was frivolous was Nutramax refusing to pay for product they received until suit was filed. And once suit was filed, they paid the $1 million for the product they received, but didn't pay the delinquency interest and collection costs. Having to do the suit at all was what was frivolous, and that was a bargaining ploy that they were trying to use in the international arbitration dispute.
Okay, I see you have some rebuttal time.
Yes.
Why don't we let Mr. Patterson speak?
Thank you, Judge Niemeyer. May it please the court, Jeff Patterson on behalf of Nutramax. I probably could not give the court a better example of what the district court had to deal with than what's happened today. And I want to start with the denial. There are three issues before the court. Let's be clear about that. One is the summary judgment on novation, which from what I hear from my brother counsel, he doesn't dispute that the court correctly granted summary judgment on novation. Although that's been raised, there's no evidence in the record to suggest the court was wrong on novation, and therefore I think the court has to affirm that. The other issues that have been raised is this idea that, well, even though the fourth amended complaint was denied, somehow there was consent to amend it over the court's ruling because of exhibits put in at summary judgment. And I do want to address that.
And then to close that out, I understand opposing counsel to say because of all that, then Rule 15b2 required that the amendment be made to the fourth one.
Yeah, that's correct. And there's two problems with that, Judge Thacker. The first of all is opposing counsel is confusing the idea of admissibility with evidence and new claims coming in. All of the invoices are relevant to novation. I mean, it's a breach of contract case. The invoices are going to be relevant for purposes. The question is for what purposes and for what claims. And what the trial court said in denying the motion to amend the fourth amended complaint to add this, what I'll call modification theory, was it's 2 years, we're 5 complaints in. You now say this is the most basic document in the case that you had, but you didn't understand exactly what it was for 2 years. We spent all this time. No, I'm denying your right to add a fourth amended complaint to completely change your theory again. And the court said that very clearly. Then when we move to summary judgment, the fact that there are exhibits in that may or may not be relevant to any claims, that doesn't consent or change anything. If you look at the Dan Ryan case and the People for the Ethical Treatment of Animals, 2 Fourth Circuit cases that talk about this 15b2, I think Dan Ryan was actually at trial as opposed to summary judgment, but I think the same rule applies, which is basically for that to apply, for you to have an implicit amendment to the complaint, you have to have evidence that the new facts or arguments presented were effectively the same as moving the court to amend, and the district court, by hearing it without any objection, showed its willingness to allow the amendment. So it's almost an amendment by implication. Here you've got the exact opposite of that. There were repeated attempts to bring this into the complaint, which the district court rejected. In the summary judgment, Nutramax, my client, repeatedly objected to anything beyond novation because that was the only theory, as Judge Niemeyer pointed out, that was alive at that point in the third amended complaint. And so my clients objected over and over and over again to saying the only thing left is novation. That's the only thing that we have. So this idea that somehow 15b2 could be stretched so far as an end run around a clear ruling against an amended complaint. And Judge Richardson, you suggested, I don't think there is any limit to the argument the other side is making. I think what he's saying is no matter what the district court says pre-trial, I can show up, and if I put in a piece of evidence at trial and it comes in without objection, I can make whatever arguments and claims I want to make, no matter how many times they've been denied previously. There's no way that can be the law. That would mean rulings on motion to amend are essentially meaningless. And so when you get to that point and you say, okay, if the complaint is not amended by implication, the only issue before this court is novation, and there is zero evidence that there was a novation. The court has laid it out, and therefore you have to affirm. Then you just move to the one remaining issue is the sanctions. Bad faith. The court, if you read the district court's orders.
It doesn't have to be bad faith, does it? Sanctions can be imposed for just multiplying litigation.
That's correct. Abuse of the judicial system or misuse of the judicial system is another phraseology that's used, Judge. You're exactly correct. And if you look at the rulings, you can see starting from the dismissal of the first complaint, the second complaint, the third complaint, you can see the growing frustration from the court and also the growing warnings of the court saying, you're getting to the end of your rope here. You've changed your theory now 3 times. We're 2.5 years into the case. You've cost the court a lot of time. You've cost Nutramax a lot of times with these ever-shifting theories. The court referred to it as a game of battleship. Every time one theory would get torpedoed, they'd say, well, let's try this one. And what it-
And money defending these claims that can never be made,
right.
can never be proven.
Well, and if you look at it, just the record on appeal, there were hundreds, if not thousands of pages of briefs written on this. And what was frustrating to our team and our client was the way that I think you should go about this is you determine the facts first, and then you see what legal theories, if you're the lawyer, what legal theories can grow out of those facts. What we seemed to have happening here was, well, what legal theory can get me around the judge's ruling, and then I'll try to reverse engineer some kind of facts to do that. And I do think that's, at its base, improper. The court did say it wasn't dishonest, but it was a misuse of the judicial proceedings, and I agree 100%. The first thing you do in a breach of contract case is get all the invoices and get all the contracts and look at them. For some reason, they didn't do that here. They pled a whole bunch of theories through 3 or 4 complaints, and then they say, you know what, we finally went back and looked at these invoices, and now we want to try our 5th theory. That is entirely unfair to my clients who had to pay, my team to motion to dismiss, motion to reconsider, motion to dismiss, motion to reconsider, motion to dismiss, motion to reconsider. Dozens and dozens of hours and tens of thousands of dollars. We appreciate the court ultimately awarding, but I would submit that the court was beyond reasonable in saying the only thing I'm going to award fees on is that last motion to amend. And even with that, they cut it back to about a $5,000 fee award. I think the district court showed great restraint. I think they could have said, everything since the first complaint, I'm awarding all those fees. I appreciate that the court has to be reasonable and sanctions are the exception, not the rule. But in this case, and given the amount of time and effort and just unwillingness by opposing counsel to basically listen to the court and accept the rulings and move on, we got stuck in this loop, which we saw here repeated today of the same thing over and over. And no, I don't agree that the court ruled that, even though the court has clearly ruled it. So what we would submit, Your Honors, is the ruling on summary judgment on novation, I think, has to be affirmed because there's been no argument advanced to change it. There was no implied implication under Rule 15b2 that the complaint was amended and that there was a new theory of modification. I do think that the reason the court addressed that—
What did the court do on the alternative theory of the complaint that there was an assignment?
That in allowing the third amended complaint, the court only allowed the third amended complaint as to novation. It did not allow the third amended complaint as to assignment because it said there's no theory pled in here that would support an assignment. In other words, there's no facts of an assignment or delegation. And even if there was an assignment, it would be assigning the contract with BioIberica Spain, that has the terms that say, or that does not have any terms allowing interest and late fees. So it was almost a futility argument. This assignment couldn't go forward for that reason. So when we got to summary judgment, the only issue left was novation. Assignment was not even as part of the third amended complaint under the court's ruling in allowing that. So the novation was what was briefed on summary judgment. The court, in its order, did say, but let me explain, even if I'd allowed the fourth amended complaint, here's why it would fail. I know for certain why the judge did that, because of what we've seen here today. The judge knew this was going to get appealed because of the history of the litigiousness of opposing counsel and constantly arguing everything. And I think the judge was just saying, okay, we're probably going to get appealed, so I do want to go forward. And I think the judge got it exactly right that when you go back to the basic UCC concepts here, this is not a complicated case. Purchase order goes from Nutramax to BioIberica Spain. BioIberica Spain then ships in response to that purchase order. They end up shipping it to Bio Nebraska, who then forwards it to Nutramax due to some import issues that are not really relevant. What the court said and what UCC 2-206 agrees with is, even though they didn't fax back an acceptance of the purchase order, shipping is acceptance. The only time shipping would not be acceptance is if the contract unambiguously says you have to accept this in writing. The purchase order here clearly said you can accept this in writing by signing and faxing it. If you don't accept it, you can just ship, and when we get it, we either have the right to accept or reject, which under the contract, we always have the right to accept or reject conforming or non-conforming goods. The UCC itself, 2-206, says even if you ship non-conforming goods, that still qualifies as acceptance, meaning there is a contract. You may have a breach because you ship non-conforming goods. So the district court was 100% correct in saying, once BioAmerica Spain ships in response to the purchase order, there's a contract. And this is why the district court kept trying to tell opposing counsel, unless you have a novation, you cannot win this case. Because once BioAmerica Spain ships, the timing of shipping is what's important. There's acceptance and there's a contract. And Nutramax's purchase order said this contract cannot be modified. It doesn't matter what's in your invoices. These terms cannot be modified without a signed written agreement. It provides for all material terms, payment amounts, shipment dates. And so under 2206, you have a contract at the time of shipment. And the only way there's going to be a different outcome is if he can prove that there was a novation, meaning that contract was set aside and Nutramax agreed to enter into a new contract with BioAmerica Nebraska. That's what the court kept trying to tell him, which he refused to accept. So under 2206, it's clear there was a contract. Again, the court correctly said under 2207, that doesn't apply here because 2207 deals with contract formation. We already had a contract. 2207 deals where you have battle of forms and there's not yet a contract and you're figuring out what are the terms of the contract. You can't, after a contract is already in place, especially a contract that says modifications have to be in writing, float in an invoice weeks later with new terms and say, well, those terms now become part of the contract. Modification, as I'm sure the court is aware, is dealt with 2209, not 2207. There's no allegation here that the contract was properly modified with a written agreement. And that's a long way of saying when the court went in and explained, even if I allowed you to amend, you still wouldn't change the outcome in this case. I think it's an alternative ruling. I don't think the court had to get there because the only proper claim before the court was novation, which was rejected. The court was well within its discretion to reject the fourth amended complaint, giving the passage of time and what the court referred to as suspicious litigation tactics for how things were done, and really what the court recognized, the lack of any legitimate explanation as to why did it take you 2 years to even look at the invoices in a breach of contract case? It's never really been explained, and there was never, in the court's opinion, justification for that. So in denying the fourth amended complaint, the court was right. 15b2 doesn't save them for the reasons that I've discussed. There was no indication that the district court impliedly consented to this new claim or that Nutramax did. They were consistently objected to. And finally, Your Honor, I do think the bad faith / abuse of judicial process award of about $5,000 was appropriate given the number of times and the amount of money that was spent fighting these same issues over and over again, which was only necessitated by counsel and his client's refusal to listen to the court and accept the orders of the court. I'm glad to answer any further questions the court has if necessary.
All right, thank you, Mr. Patterson.
Thank you.
Mr. Gebhardt?
Yes, Your Honor. Let me explain how all of this arose. The initial invoice that was attached to the complaint and the amended complaint was an intercompany invoice with no payment terms. Nutramax refused to pay for all of the invoices sent thereafter, like the 3rd through the 5th. They had payment terms and so on. The district court correctly said the battle of forms 2207 only applies to the formation of the contract, not once the contract is formed. Your initial invoice did not challenge anything. So then came the issue of, well, how can these payment terms, because there were no payment terms in the purchase order, didn't say when they had to pay. They could still not have paid today. How do we get those payment terms in? And BioAmerica Nebraska was a collection agency, so the concept of novation then arose. But it turned out there was no novation because there was an original invoice sent and delivered with the initial installment of goods that Judge Gallagher never considered in the original ruling. She didn't have it before her. But that original invoice negated any possible acceptance by shipment under 2206.
Well, I think to understand the court's position is that when you ship in response to a purchase order, it forms a contract. and the invoicing after shipment doesn't alter that. The invoice is basically requesting the payment of money.
It was with the shipment, not after the shipment. That was an undisputed material fact.
Except it was not communicated to the Nutramax until it was received. Yet it was shipped much earlier. It was shipped in December. Wasn't it shipped in December?
Nutramax says the goods went
Sir, I asked
from-
you a question. Were the goods shipped in December?
I'm not sure when they were shipped. They were shipped,
I think they were shipped in December, end of December.
okay.
Now,
Nutramax
at
says
that point, why isn't there a contract?
because they didn't reach Nutramax. Nutramax says they
There's
went
nothing in
to,
the UCC that says it has to reach them.
it
It
says,
says you issue a purchase order, and the supplier ships in response to the purchase order. It's the formation of a contract.
no. The UCC 2206 does not say that.
207.
Well, their shipment is 2206. It opens up and says, unless otherwise unambiguously indicated by the language or circumstances, when a shipment is accompanied by an invoice rejecting the terms of the purchase order, that's language unambiguously indicating to the contrary. It is not. Nutramax says we got the initial shipment from Biobarrick in Nebraska, which was accompanied by the invoice, the questionable invoice. We had both of them together. That invoice said, we reject the terms of your purchase order. If you don't agree, then return the goods to us. If you want to keep the goods, then pay us and the terms of our invoice apply. And that is beyond dispute. There is no dispute whatsoever in the summary judgment facts presented by both sides. There was no, shipment did not qualify by itself. How could you possibly reject the terms of a purchase order if simply putting the goods in transit with an invoice?
Simply return a fax or a letter.
Well,
The normal process, I think, I was a purchasing agent for many years ago, and we issued purchase orders and we got acknowledgments back. And promised shipping dates. But once there was a shipping, a product was shipped, that's acceptance of the purchase order. Now, the question is the invoice that comes thereafter, and in this case it came thereafter, it came with the arrival of the goods, not the shipment. The idea is, when did the supplier choose to accept? And the supplier chose to accept by shipping. They could have rejected and say, we're not going to ship. They could say, we don't agree to those terms on the purchase order, but they shipped.
No.
And so at that point, an invoice that comes to the purchaser later hardly changes that under the UCC. But I don't think that's before us. I think what's before us is two things. Did the district court err in dismissing the novation theory on summary judgment? And second, did the district court err in denying your motion to amend?
Well,
if the court is correct in denying the motion to amend, that ends the case, right?
if the court had no discretion about the motion to amend. May I address the point about the shipment and the invoice and so on? Because even if you said shipment by itself constitutes an acceptance, under 2207 subparagraph 2, it says the acceptance may contain additional terms beyond those in the purchase order. And the purchase order had no payment terms whatsoever. The invoice had payment terms. It says unless there is an express disclaimer of you're saying you must accept only these terms in the purchase order, which was not the case here, the additional terms become part of the contract. The purchase order said you may not change any of the commercial terms, but purchase terms are boilerplate terms. And frankly, Your Honor, you authored an opinion characterizing purchase terms as boilerplate terms. Those additional terms became part of the contract even if shipment put the contract in place. The point is,
All right, I think I understand that. We've gone through the red light here again.
Yes.
All right. Thank you, Mr. Gebhardt. We would normally come down and greet counsel. As you know, as I explained earlier, we're going to forego that because we're continuing with the pandemic protocols, the COVID protocols so far. So I want to thank you for your arguments, and
Thank you, Your Honor.
Thank you.
we'll take a short recess.
This honorable court will take a brief recess.
Thank you, Your Honors. May it please the court. Pete Patterson for the appellants. The district court's decision in this case must be reversed for two reasons. First, the reasoning and holding of this court's
Do
decision.
you have a microphone on? Where's the microphone? Yeah,
Right here.
Just lift it up a little bit. Yeah.
Okay.
That's good.
Is that better,
Thank
Your
you.
Honor?
Yeah.
Thank you. The reasoning and holding of this court's decision in Colby has been undermined by the Supreme Court's decision in Bruin. And second, under the Supreme Court's decision in Bruin, Maryland's ban on popular semi-automatic rifles is unconstitutional.
Okay, well, you filed this suit in 2020, right?
Yes.
And so Colby was good law then. Why wasn't your lawsuit frivolous at that time?
Well, it was a good faith effort to change the law. This case is the exact same
Based on,
posture
right, based on
as
what?
based on trying to get it to the United States Supreme Court. And that it was an incorrect decision. And we submit that under Bruin
Was Heller an
vindicated that
incorrect
case.
decision?
Excuse me?
Was Heller an incorrect decision?
No, Heller was not an incorrect decision.
And
Your
is
Honor.
Heller still good law?
Yes, Heller is
Okay,
still
so
good law.
Colby was based on Heller.
Colby was based on Heller, but Colby misapplied Heller as confirmed by Bruin. Bruin did not change Heller. Bruin clarified Heller. Bruin said that the levels of scrutiny analysis was never a proper mode of analysis under Heller. So it wasn't purporting to change it. It was saying the Court of Appeals had been doing this incorrectly. And then Bruin also said that in Heller we held that law-abiding citizens have a right to use firearms that are in common use today. And that is the analysis this court
And
declined.
Justice Alito's concurrence in Bruin said that Bruin does not decide anything about the kinds of weapons that people may possess, which was part of Colby's ruling.
Well, that was in a concurring opinion.
Did anybody in the majority opinion say, Justice Alito, that's just completely off base?
No, but that is because Bruin was not changing Heller, but it did clarify Heller with respect to what this court held in Colby when it said that we held that law-abiding citizens have a right to own firearms that are in common use for lawful purposes as opposed to firearms that are highly unusual in society at large. And that's
Do you have
the
any
very
evidence in the record that the types of firearms banned by Maryland are in common use for lawful purposes?
We've cited a lot of evidence in our briefs, Your Honor, including that there are over 20 million of these firearms in the United States, that roughly 60% of the people use these for self-defense in the home. Purchasers of these firearms rate 8 out of 10 self-defense as a reason for using these firearms. They're 20% of all firearms sold in the nation in recent years.
Where in the record is that 60% of people use assault weapons
This is
for
in
self-defense?
survey of William English, the report of William English that
Oh,
we've
it's a
cited in our
survey.
brief, that
in your
says that.
brief.
And that's exactly the type of evidence that Heller relied upon. If you go drill down on Heller's citations, the source for the assertion that handguns are the most popular firearms for self-defense was a social science paper by Gary Kleck. So it's the same sort of evidence that Heller relied on, and as Judge Traxler said in his dissent in Colby, the fact that these firearms are in common use is beyond debate. Every court that has considered this issue has held that these firearms are in common use. And perhaps the most telling one is Justice Kavanaugh's dissent in Heller, too, while he was on the D.C.
But you
Circuit.
agree it's not just whether they're in common use?
Yes, it's just whether they're in common use.
No, in common use for lawful purposes.
Okay, common use, yes, common use for
That's the
lawful
part
purposes.
you keep missing, because if it's just common use, then we can't have bans on any weapons anywhere. Everybody could have a gun in here if they wanted.
Okay, common use for lawful purposes, yes, Your Honor, but as Judge Mannion said in his dissent in Friedman, if law-abiding citizens own something in large numbers, ipso facto, those are used for lawful purposes, if these law-abiding citizens are owning them. So if you've got tens of millions of citizens owning a type of firearm, they're necessarily, if they're law-abiding citizens, they're using them for lawful purposes.
If they're law-abiding citizens.
Yes, but in any event, we've got the evidence in the record that these are used for
Mass
over 20 million.
shootings, killing of law enforcement officers, there's evidence that that's what they're used for,
No,
correct?
there's evidence.
So only law-abiding citizens are not the only ones
Not
using
only,
these.
but as Judge Kavanaugh said, if you're going to call a weapon an assault weapon, the true choice of firearm for criminals is handguns. Handguns are used to kill people 20 times.
I guess your
more
response is,
often than
though,
any
that the
rifles.
statute reaches to deny lawful persons from possessing.
Correct. The statute does not just prohibit unlawful uses of these firearms. They prohibit lawful uses. And the evidence that they've pointed to actually strongly undermines their case, although whether criminals misuse these, whether there's some sort of public interest is irrelevant
What
after
evidence
Bruin.
strongly undermines their case?
Their citation to the Coper report from 2020, which said these firearms are not different than any other semi-automatic firearms. They don't shoot any more lethal type of ammunition. And Coper cited 2 other studies. One from someone named Blau, who found that the use of these firearms in mass shootings was not associated with increased lethality, but the use of handguns and shotguns is. So if anything, these are the least associated with lethality in mass shootings. And then a citation to a study by Webster, who said that states that have bans on assault weapons, they're not associated with less lethality in mass shootings. So their own evidence that they've cited undermines their case.
Can you talk to me? I understand that we're sort of talking about the 2 pieces here, common use and lawful purpose. On common use, we now say common use at this time. Do I think about that in the same way that I think about the 8th Amendment after Roper? Is it the same sort of analysis?
I'm not sure, Your Honor, 100%. I haven't studied those cases, but it's a similar analysis in that we look at today's society. We see what is in common use. Bruin made very clear, and this was a critical part of Bruin's.
All right, so let me go back to, okay, what do you think of, you gave a couple of different examples, but what do you think of as being the denominator, right? When we think about, is it in common use, right? That implies there's a numerator and denominator. Can you help me understand what you think the right denominator and numerator are? I mean, you mentioned at one point the number of guns, at another point, the number of people that own them. What's the metric that I'm looking at, the numerator, denominator?
The numerator, I think, is the number of the firearms that are
Not the number of people?
I don't.
I mean, because you could say it's the number of 20 million firearms, but you could also say there are 20 million people that own them. Like,
Yes.
Are those different?
I don't think they're different. The Supreme Court hasn't delineated between the two, and here the
I know, but I'm looking for help from you, right?
Yes.
Is what should the denominator be? And then what should the numerator be is what I'm trying to get at.
Right. And the reason I'm struggling a bit is I think it's just the total number, and we can see this in Justice Alito's concurrence in the Catano opinion when he says there's 200,000 stun guns, and that shows that they're in common use across the nation. And he doesn't have a denominator. He just says it's an absolute number. And I surely, given again in Heller 2 at that time, there were about 1.6 million of these firearms that were in circulation, and the court said that clearly is common use. I think and so no one has ever looked at the owners versus the firearms. So I think the firearms is the relevant numerator. And the evidence here in the English survey, the median number that the owners have owned is 1. So those numbers are likely pretty close in any event.
So then switching to the second piece, the lawful purpose piece. A number of courts in the recent iterations have focused on the self-defense rationale. But if we go back in time, obviously that wasn't the only rationale. There was also a civic rationale in addition to, and so when we see cases like Heller and Bruin, they're talking about the self-defense in addition to the civic purpose. Would the civic purpose work here? So in other words, are you limited to saying the lawful purpose is self-defense? That seemed to be the focus, as opposed to the civic purpose, which, check on tyranny and the like?
Well, so it's any lawful purpose. So
that's what I'm getting at. Do you think those are lawful, or the civic purposes, what we might think of as the civic purposes behind the Second Amendment?
Well,
are those things that, so in other words, if you had a statistic that said 20% think it's self-defense and 20% think that they want to have them in case of tyranny.
Right.
Are those both legitimate concerns?
I think those are both legitimate concerns. I think there would be a lawful purpose, and that's what, and in fact, that would show how the right dovetails with what Heller said was the purpose, because the purpose was that people would bring their commonly possessed firearms to militia service. So that would be a legitimate purpose. But here we have the evidence again. That's clear that self-defense is a common purpose, target shooting is a common purpose, hunting is a common purpose for owning these firearms. Again, the English survey shows that those are all common purposes for owning these firearms.
Can I ask one more follow-up question, then I'll let you go back?
Yeah.
So you might think about Bruin as setting up a two-step. I know it rejects the old two-step,
Right.
but you might think it sort of adopts a second two-step, which
Yes.
is, do you fall within the Second Amendment protection? And we think about that both in terms of, are you people, right, law-abiding citizens maybe, or law-abiding something, and then also with respect to arms. So that would be step one. And then step
Right.
two is there some historical analog permitting this type of a restriction? And so one, I want you to talk a little bit about, is that right? Is that the right way to think about Bruin? And then second, am I right to think about step one being the plaintiff's burden and step two being the defendant's burden?
You're right about thinking that. The court hasn't assigned a burden at step one. I think it's a purely legal question, so I'm not sure the burden
No,
really.
I thought it explicitly said, it says it's holding, it says that if it's a weapon in common use and is implicated by the First Amendment, it's presumptively protected by the Second Amendment. And then it says the government must demonstrate that the regulation is consistent with the nation's historical tradition.
Yes.
Right, and that's that answers step two, right? I'm asking about step one. Yeah.
And what our submission is that whoever's burden it is, Heller has already decided this. It says that as a matter of text, the Second Amendment arms means bearable arms. So the only question as a textual matter is, are these bearable arms? And the answer is undoubtedly yes. No one disputes that. So then it falls within the plain text. And then we go to, as you said, step two, although the second part of the one-step analysis that we
It's a
now have.
rebuttable presumption.
And which is now we have a presumption, and the other side has an opportunity to come in and say this is consistent with the nation's history. But here, the Supreme Court has already done the history as confirmed by Bruin and said there are two kind of different traditions at the founding that support.
So help me understand why
Yes.
you're putting the common use at the second step. I
Yes.
put it at the first step. Help me understand why you're making that move. It seemed to me that when they're defining arms, they're suggesting common use at the time for a lawful purpose was what was covered by the Second Amendment, not what was the historical analog as an exception.
Well, right. If you go to Heller and again repeat it in Bruin, it says the Second Amendment extends prima facie to all instruments that constitute bearable arms. So
In
we
common
take that.
use, they all include that in the first step.
Not at that point, Your Honor. It said, if you look at Heller where it's talking about defining arms, it says it prima facie extends to all instruments that constitutes bearable arms. And then it goes to talk about limitations on that. And it says one limitation we've found is the carrying of dangerous and unusual weapons. So that is a limitation on the textually
And
defined
that's what
scope of the
Colby
right.
was based on. That premise, that statement in Heller, that's what the Colby opinion was based on. Where in Bruin does the court discuss the primary basis for the Colby ruling, which was, quote, because the banned assault weapons and large capacity magazines are clearly most useful in military service, we are compelled by Heller to recognize that those weapons and magazines are not constitutionally protected. That was Colby's primary basis. Where does Bruin talk about Colby in that respect?
Well, it doesn't mention Colby by name, but this court's precedent does not require that. At 2128, Bruin says the Second Amendment protects the possession and use of weapons that are in common use at the time. And Colby expressly refused to conduct a common use analysis and said, we aren't doing that. So Bruin undermines the reasoning of Colby. And this was key to the Bruin opinion when discussing
Well, actually, Bruin, I think, discussed how weapons generally begin in the military and gravitate or migrate to the civilian population, and that it's only, the only analysis is to look in the common use, regardless of whether it came from the military or was like the military.
Right, Judge
And
Niemeyer?
they gave examples from going back to the Lanscays. And
Right, and I was going to mention the example of this was key to the court's decision in discussing New Jersey restrictions, colonial restrictions on carrying handguns. The court said, well, maybe they were considered dangerous and unusual at that time, but they certainly are not today. They're in common use today, and that is the test. And so just as this court in the Banks decision, which we cited in our 28J letter, a prior in-bank decision of this court had applied a Supreme Court decision called Styrone, and then later cases from the Supreme Court demonstrated that this court's application of that Styrone case was incorrect and said that the reasoning and holding of that decision was inconsistent with later Supreme Court decisions, and therefore we're no longer bound by it. So that's the same reasoning that applies here in this case. So I'm about at the end of my time. If there are no additional questions, I'll save time for rebuttal.
All right, Mr. Scott?
Good morning, Your Honors. May it please the Court, Robert Scott, Assistant Attorney General for the State of Maryland. Here today with me at council table is Brian Frosch, the Attorney General of Maryland. Contrary to the plaintiff's assertions, the Supreme Court in Bruin left intact the portion of this court's en banc opinion in Colby holding that assault weapons banned by Maryland law are not protected by the Second Amendment because they are similar to M16s and other military-style weapons more suited to use in the military. As Justice Alito stated in his concurring opinion, and as Judge Thacker pointed out a few moments ago, Judge Alito said, our holding decides nothing about the kinds of weapons that people may possess, nor have we disturbed anything.
It doesn't decide the kinds of weapons, but it gives the test, right? So that's the rub, right? It doesn't decide which kinds fit the test, but it gives the test. When we look at 2143, the discussion there gives the test, which is, common use for a lawful reason.
Well, actually, Bruin uses the language common use for self-defense.
Correct, because the issue here with firearms, and they're talking about it in a self-defense context, but the idea is for a lawful purpose, whether self-defense is that purpose, which it was in this case, or it might be a civic purpose in another case. The point is, it gave the test. It didn't answer the question. That's why we're here.
Right, but this court has already answered the question, Your Honor, and this court in
Applying
Bonk
a different test, though, is the problem, right?
Well, but Bruin didn't reject the test that this court applied.
It adopted a different one. That is a rejection,
in the
right?
context of a carry law regarding handguns, not with respect to assault weapons. And that's was that issue in Colby.
Can the test that we employed in Colby coexist with this different test that the Supreme Court opined in Bruin, assuming it is a different test?
Absolutely. I don't think they're inconsistent, Your Honor. I think they're
Well, I thought in Colby,
consistent.
we said that if it's of a kind like used by the military,
Correct.
and that is not the test, whether it's of the kind. The determinant is not whether it's of the kind of the military. The determinant is whether it's in common use. And in the recent opinion, the court went through and explained example after example about weapons that were military weapons that were then used in common use by citizens for self-defense. And I think that if it wasn't explicit, it was pretty close to explicit, saying the fact that it was used in the military or similar to use in military is not the test.
Well, but that's what Heller says, Your Honor. And
No, Heller doesn't quite say that. I read that, and I don't want to criticize our Colby decision. But Heller says, talked about military something and like, but then the conclusion in the rest of the sentence doesn't reach the comment. But quite apart from that, we're here under a case where the Supreme Court gave a GVR to the opinion in this case, and the opinion in this case rested solely and singly on Colby. And the court said this was wrong and sent it back. It didn't say it's wrong, it granted a GVR. And so here we are under it. So there's a pretty close attachment between this case and Colby. As a matter of fact, it's a one-on-one attachment. Judge Berdar only relied on Colby in a single paragraph, and it went up. And of course, as you know, in Supreme Court cited Colby a couple of times as somewhat of an outlier. in its opinion.
Right. Well, I mean, I don't think there's no question that the means end scrutiny analysis that was applied in Colby is
Yeah, but the
is off
test involved two steps, and we defined one or the other. The new test is a single one-statement test that's inconsistent with what we applied in Colby. The new test is it a bearable arm in common use for a proper purpose? And they said the heart of the proper purpose is self-defense in Colby. So that's the whole test. If that's the test, it's covered by the Second and First Amendment. That's not what we said. That's not the test we applied in Colby. So then the second proposition was, and it rejected any second step, and basically said that creates a presumption of coverage, and it allows the government then to demonstrate the nation's historical traditions
Well, Your Honor, again,
to rebut the presumption.
Again, Bruin doesn't say anything about the holding in Colby based on the fact that these weapons are similar to
No, it didn't address Colby, but it
military
cited Colby a couple of times as an outlier. It's sort of like but see, and it was addressing this, and it clearly was focused on this because the GVR in this case was a Colby case.
I understand
Nothing
that.
more than a Colby case and nothing less than. It was a single paragraph that relied entirely on Colby and went to the Supreme Court.
I understand, Your Honor. Our point simply is that in order for this panel to overrule the court's unbiased opinion in Colby, you have to find that Bruin specifically rejected the reasoning and holding.
All we
in
need to
Colby.
do is to follow Bruin. We don't need to overrule our prior cases. If the Supreme Court comes in with an intervening case that controls what we're doing here, we apply the Supreme Court, regardless of what we did before.
Well, right, but
I mean, we don't have to gratuitously
court's
go out and
precedent-
say it's overruled. What we have to say is this case, how do we determine this case in light of the Supreme Court's subsequent decision, which is before us?
Well, under the Banks case, which the plaintiffs cited in their supplemental authorities, which is at 29 F. 4th 168, this court said that a superseding contrary decision of the Supreme Court must specifically reject the reasoning on which that the decision is based.
And I would think that sounds right. And the question is, does it reject the notion that relying on military likeness is the proper test? And the answer is it did address it explicitly and said that's not appropriate.
Well, we disagree with that interpretation, Your Honor. I don't believe Bruin says that explicitly. I don't think it implies it. I don't think it addresses it at all. I think it leaves that question open. And because that question is left open by Bruin, this court must follow Colby, unless you find that the reasoning was specifically rejected, and we don't believe it is. However, in the alternative, even if this court were to find that, were to rule that Bruin did specifically reject reasoning in Colby and overturn that decision, the case cannot be decided at this stage. It needs to be remanded to the district court so that there can be a development of a record in this case
Well, why
before a
isn't
decision
at least
can
the
be made.
the text of the amendment cover these arms? In other words, to me, that is the test basically is in common use. That's the essence of the test. And I think even in Colby, we recognize that these semi-automatic long rifles were in common use.
Well, there's been absolutely no discovery on that issue. We've not been, this case went from a motion to dismiss, which was affirmed on appeal. There was no discovery. There's been no
Well, you take
opportunity.
issue-
What is the discovery that you're going to do?
We dispute that these weapons are in common use for self-defense.
And what discovery, though? I mean, what are you going to get
Well, I
from
think
the
if you look at
plaintiffs?
I think if you look at the Miller case in California and the filings in that case, you'll see the kind of discovery that we would do. There are statistical experts who've provided declarations in that case.
But nothing you would get
regarding-
from the plaintiffs, right? I mean, when you say discovery, you mean we would go do our own work. We'd get an expert or we'd
And we
develop our-
cross-examine their experts, and there would be, an adversary proceeding. That's the whole purpose of discovery, is to find the truth, right? To find out what's actually.
To find out whether this COPA report is accurate, that 60% of people that own these guns use them for self-defense, as opposing counsel
Well,
said?
What that says is that the 60% of people who were asked said in a survey that they
Well,
bought
they
them for
didn't say, I'm going to
self-defense.
use it to go shoot up a Walmart. They said, oh, it's for self-defense.
Right. So, Your Honor, this is exactly why you need discovery. You need to probe the assumptions, the methodology of these studies and find out whether they're actually reliable. There's been none of that. They're just citing to studies, some of which were produced by a trade association
So
for
is
the
the
firearms
right,
industry.
I want to understand procedurally what you think, assume hypothetically, I understand it's not your argument, assume hypothetically that I found that Colby was overruled by Bruin. Your position would be, we should say that, because we have to say that in order to send it back, but then it should go back down, and then if they want to move for a preliminary injunction, they can do that, or it can go to discovery, but that's all what ought to take place at the district court. And if they seek preliminary injunction, then maybe the district court makes the decision based on the record that's available at the time. Maybe not, maybe they wait and do discovery, who knows? But all of that ought to happen there. That's your
Right,
theory.
that's what happens in a civil case. That's the normal procedure that you follow, and there's no reason that this should.
I mean, that's not what the court did in Bruin, though, right? I mean, that's the rub that you've got here, is that the court in Bruin doesn't do that, right?
Right,
It says in fact, rejects the idea. It says basically, we can look at this because you filed a brief with all the information that's available. They filed a brief with the information that's available, and we can look at it and make those sort of legislative type determinations.
Right, but in Bruin, there was no dispute that the weapons at issue were in common use for self-defense.
Do you
It was
dispute that?
handguns. So, I mean, nobody was saying, oh, handguns are, in fact, Heller says it's the quintessential self-defense weapon. That's not what this case is about. In
okay,
this
but
case,
then why don't we-
We dispute that these weapons are in common use for self-defense, and we're entitled to probe their
So why
alleged
don't you,
evidence on that.
why isn't that rejected by Staples, right? So Staples says, which is an AR-15 case, right? It's not asking the precise question of are they in common use, right? But it says they've traditionally have been widely accepted as lawful possessions or something to that broad effect, right? I mean, that's the Supreme Court, admittedly, maybe it's dicta, but, we give dicta, even at the Supreme Court, a fair bit of deference here, right? They're resolving that question, right? A question that, obviously has evidentiary support.
But this question is specific to a specific Maryland statute, which has a specific definition of what's covered and isn't covered.
But if a
And we're
subset
entitled
of
to-
that is widely accepted, right? So that was addressing the AR-15. And so if that is widely accepted in common use, then the broader set, which is all the other things that you're included within the Maryland ban, is by definition, right? So that's just a broader set. There are
No,
more
well,
of
they're
them.
asking for the entire ban to be declared unconstitutional, including the parts of the ban that apply to guns which are not in common use for self-defense. The
So you
law
think you have to
covers-
do it on you don't, no, but we look at the law and we say, is the law constitutional? No, because it bans these guns.
The
So
law-
we
but the-
enjoin the enforcement of the law. We
The law
don't
lists-
rewrite it for you.
The law lists lists specifically enumerated weapons which are banned. And there's nothing in the record that would permit the court to determine which of those weapons are in common use and which are not.
Well, if
That's
it's
why you need the
overbroad-
development of a factual record. This is a decision for the district court. If this court's going to rule that Colby's is overruled by Bruin, here's the test, you have to apply it. It goes back to the district court, and the district court in the first instance should apply it based on a factual record that's developed in the normal course. There's no reason this case should be treated any differently than any other case. This is an important case.
No, we just
of
treat it just like Bruin did, right? I mean, that's the rub, right, is that we've been told by the Supreme Court that it doesn't have to do that.
But Bruin involved, there was no dispute that the handguns are in common use for self-defense. In this case, we dispute that these weapons are in common use for
But there were
self-defense.
other disputes, right? They didn't dispute the common use point, although that was a critical part of Bruin, I acknowledge. But they were lots of other disputes, right? That's why they had all the historical records that they were going through, right? All of those were disputes. And the Supreme Court said, we don't need to send it back. We get to do this.
Right. Well, again, in this case, we
Well, you agree there were disputes in Bruin on the record.
There was different interpretations of the historical information that was provided. But in this case, we
On a motion to dismiss, right?
But we didn't do this on a motion to dismiss. We did it when Colby was the law. That's what the briefing was. Now we have, if the court says we have a new test, we have not been given the opportunity to submit anything other than what the court could take judicial
And
notice of.
the opposing side admitted Colby was the law when they filed this
Correct.
complaint. They just didn't like that it was the law.
Correct. And so when the court, and in fact, we actually filed an answer to the complaint because we wanted to do discovery in the case. And Judge Brodar said, well, wait a minute, you filed an answer? Why? There's binding precedent, and we had a conference with the judge, and he said, why did you file an answer? And we explained to him because we wanted to do discovery for the development of a factual record, because we knew that the plaintiff's goal was to get this case to the Supreme Court, and we wanted a full record. And Judge Brodar said, well, I'm sorry, but I'm going to have to dismiss this case sua sponte because there's binding precedent.
Opposing counsel also says that Justice Alito's concurrence, where he says that Bruin does not decide anything about the kinds of weapons that people may possess, is really of no moment here because it's only in a concurrence. Do you have a response to that?
I disagree. I think it's very relevant and very important, and I think that
But it is a concurrence.
It is. I mean, I'm not going to, obviously, that's correct. Factually, it is in a concurrence. But I think it's also right. I think that Bruin doesn't decide anything about what kinds of weapons people may possess, and that remains an open question. And this court's en banc opinion in
I thought
Colby
that was
controls.
just a generalization saying that we don't per se rule on particular firearms. We apply a standard. The standard is bearable arms in common use for self-defense. And it seems to me that, he says, is the text of the amendment. And all we have to find, the discovery doesn't add anything to the statute. The statute regulates AR-15s.
But
And the question is, if AR-15s are in common use for self-defense, then the statute's too broad. We don't have to go down all 58 or how many weapons are there. You just have to find it's overbroad under the Second Amendment.
But discovery does go to whether these weapons are in common use for self-defense. And they've pointed, the only evidence they've pointed to is a newspaper article of one incident involving one of these weapons being used for self-defense. That's it. We have numbers. They say there's 20 million of them in circulation, but they don't have any evidence that how many of these have actually ever been used for self-defense.
The court has never said that you have to show that somebody shot somebody coming in the house. The whole question is, why did a person purchase it?
Well,
And
the test is common use, not why you purchased it. It's common use. It's not just common ownership. There's a difference.
I'm going to the self-defense prong.
Right, I understand that, but Your Honor, but I think the point is that they have to be in common use, meaning that they've been used for self-defense commonly, and there's no evidence of that in this record. All they're doing is citing to studies say a lot of people own them. That doesn't meet the test. And so
In Heller, what was the evidence that the firearms in D.C. had been used regularly for self-defense?
Again, it was not in dispute. There was no dispute on that issue.
Right, because they didn't require the type of evidence that you're demanding.
that's
If
a
they had
different-
required that evidence, then there would have been a dispute about it.
There's a different, no, because I don't think you can really dispute that handguns are in common use for self-defense. I mean, that's not something that's, it's not disputable.
Why do you say that?
Because,
we have records, there are cases that have cited the statistics, including Colby, that talks about millions and millions of AR-15s purchased by citizens who are lawfully owning them.
But the question is, are they commonly using them for self-defense? And there's no evidence in the record to establish that.
So I just want to make sure I'm clear that there cannot be disputed that handguns are in common use for self-defense.
Obviously, the District of Columbia didn't dispute that fact because when you read the opinion, it's clear that it wasn't a disputed fact. And it wasn't disputed in Bruin either. We're not here to make the argument that handguns are not in common use for self-defense.
Caetano, what was the evidence that the stun guns were used for self-defense in there?
Well, that was a criminal trial, and I don't know what the evidence was.
I'm just asking you, what is the...
It wasn't recounted, and it's not recounted in the opinion. I think Justice Alito referred to 200,000 of them.
He still talked about it for self-defense.
He did, yes, yeah. Right, but there's no, the opinion doesn't describe any evidence. It's a per curiam
Does your
opinion.
case rise and fall on whether these weapons are for self-defense?
That's the test, according to Bruin.
I said, does your position rise and fall on that question?
I'm not going to concede, Your Honor, that if we lose that point, we lose the case. No.
What other aspect to create the presumption? In other words, we have a regulation that regulates AR-15s that are in the millions in the public, owned in the millions in the public by lawful citizens. And the only open question is that did the citizens buy them for self-defense?
Well, I think before you even get to that question, Your Honor, as I've said at the beginning of my argument, it's our position that Colby's still good law, that Bruin didn't overrule it.
Well, now, let me ask you,
test
let me just ask you, this is the holding in Colby. This is a quote. Because the banned assault weapons and large capacity magazines are clearly most useful in military service, we are compelled by Heller, on that basis, we are to recognize that these weapons and magazines are not constitutionally protected. Because these are clearly most useful in the military. That's the test applied. The guns, if the guns are most useful in the military, then they're not protected. Is that the test? In any case?
Well, that's Heller explicitly
Heller did not say that.
Heller explicitly says that M16s and the like, guns like them can be banned.
Right, but that doesn't mean that guns most useful in the military. And of course, this opinion basically was addressing AR-15s and said they're like that, or they're mimicking that, or they're a civilian gun that is mimicking the military. But my question is, the holding is because they are clearly most useful in the military, we are compelled to recognize they're not protected.
And the court in Colby went on to say, although an M16 rifle is capable of fully automatic fire, and the AR-15 is limited to semi-automatic
No, I'm
fire.
talking about the test.
Well,
That's application.
but this is-
The test in Colby that because it's most useful in the military, it's therefore not protected,
I don't agree that-
regardless of the use in the civilian world.
Yeah, Colby draws an analogy between AR-15s, which are covered by the law, and M16s, and points out that they're essentially the same or similar weapons, more useful in the military. That was the test that was applied, and nothing in Bruin changes that. And unless the court has
Bruin
any further
rejects
questions.
that. Bruin doesn't say the test is what's most useful in the military, defines the line between regulated and non-regulated. Bruin says what's in common use at this point in time for self-defense.
But they also said Heller stands, and they also said nothing we said in Heller has changed. And they said we don't say anything about the type of guns that people may or may not possess under the Second Amendment. I believe that my time is up, unless the court has any more questions.
Okay.
Thank you.
Yeah, thank you. You have rebuttal. We'll get you back up here.
I don't have any.
Oh, excuse me. That's right. They have rebuttal. Would you like some rebuttal?
I'd be happy to take rebuttal if the court.
Well, let's see how things develop. All right.
Can you start with his point, what I take his point to be about severance, that in other words, we need to look at the statute on a firearm by firearm basis. Maybe the catch-all is like a little bit different, but do you agree with that? And can you
No,
talk a little
our
bit about
understanding
it?
is these are all firearms of the same basic type. They're semi-automatic rifles. That's the type of firearm we say is.
Right, but he says, listen, we've got, line one is AK-47, line two is
Right.
AR-15. And so you got to show each of those, or somebody has to show, without getting into who bears the burden, that it's in common use.
No, because they're all of the same basic type.
So tell me why I'm doing that. Right?
Well,
Why is
because
that
that's what Heller does. It looks at handguns. It doesn't say, okay, the Glock handgun, a different brand of handgun is in common
But the
use.
statute there
It says
didn't.
whether they are handguns.
But the statute banned all handguns, right? It didn't ban
Right.
a list of handguns.
That's correct, but they are trying to get at a certain type of firearm, a modern semi-automatic rifle.
Why do we have, when the
allegations have been
statute
they're all the
covers-
same type of firearms. I haven't heard them argue in a brief to say, okay, maybe that's true of some firearms, but this particular firearm is of a different type.
But that doesn't
They're all
say
the same
that.
basic type.
If a few firearms on the list of 60 are ones that are not protected, does that save the statute?
Well, it'd be their burden to show that. They haven't said
Well, my
that in any
question is, would
brief.
it save the statute if they
I
carried
think that would be a
burden?
question of severability. We haven't done that analysis,
Why
but
would it be severability? The statute as written would have to be strict, and they could maybe rewrite it.
yes, it would be facially unconstitutional.
Yes.
They could rewrite the statute. And in terms of where we go, whether we need discovery, Bruin is very clear. This case, my firm filed the complaint in Bruin, and the complaint in this case is the exact same procedural posture. In both cases, it was controlled by circuit precedent, decided by a motion to dismiss. The record was exactly the same. Heller, also a motion to dismiss, the Solicitor General of the United States asked for a remand to go down to determine things like, well, are long guns an adequate
All right,
substitute
so,
for handguns?
but help me with this. So assume I agree with you that in theory we could
Yes,
do it.
yes.
Tell me why we should, right? I mean, because I get the idea that we could, and maybe those cases tell us that we could, but we still have this basic idea that we're a court of review, not first review, right? We're a court that like wants somebody else to do the hard work, and then we get to sit back and just call it like we see it. Why
Well, this is
should
a fundamental constitutional right that's at stake, Your Honor, and every day it's being infringed is irreparable harm. You have all the evidence before you that you need to decide this issue. If we look at, for example, Justice Kavanaugh's dissent in Heller 2 on the D.C. Circuit, he looked at the same sort of information that we are citing. Justice Thomas, the author of Bruin, his dissent from denial of certain freedmen, looked at the same type of information to say that this type of ban is unconstitutional. Justice Alito, in his concurrence in Caetano, where he said that the stun gun ban was unconstitutional, looked at the same type of information. So you have all the information before you. This is a fundamental constitutional right. This is the same procedural posture that Heller and Bruin were in. This should be decided today. And one final point on the common use test. If a firearm is kept in the home for self-defense, that is being used for self-defense. Heller said the right is to be armed and ready. You don't have to actually fire a firearm in order to use it for self-defense. Hopefully no one ever has to fire one of these firearms for self-defense, but if they're kept for that purpose, it's being used for that purpose.
What about, does it also include sort of recreational use? So we think about the Second Amendment animating both a civic and an individual right. But I take the point here being lawful purpose is broader than just the Second Amendment's sort of primary interest, that recreational use would be included too?
Yes, Your Honor, and Justice Thomas says that specifically in his dissent from denial of certain and Friedman. He says these are kept for self-defense and used in training. And here we've got evidence that 20 million people a year train with these things in the United States. So we ask the court to reverse and order entry of judgment for the plaintiff.
Let me ask you this.
Oh, sure.
There's a footnote in Colby that says we invited further supplemental briefing on the use of the AR-15s. And we said, relevant to the issue of self-defense, one survey question asked this is to 500 firearm dealers, of your annual firearm sales for each year from 2011 to 14, please report the percentages you think were sold primarily for hunting, target shooting, and personal protection purposes. The respondents indicated that they think between 28.1 and 30.5 of the AR-style modern sporting rifles were sold primarily for personal protection. And of course, they report in here that it was up, I think at one point, up to 8 million sales.
Yes, so we've got.
Can we use that? Is that?
You can use that, and we have the same report, but updated, cited in our reply brief. It's the NSFF, National Shooting Sports Foundation's firearm retailer survey has the same sort of information.
And we relied on it in bank.
Yes, and you relied on it there. We have the same, we have the consumer survey from the National Shooting Sports Foundation where purchasers of these items said 8.3 out of 10, 10 being the strongest
Is there
reason
any
is home
limit to your
defense.
position? If firearms dealers flooded the market with grenade launchers or nuclear weapons, and everybody wanted to buy them then to protect themselves, that would then be in common use for a lawful purpose, I assume, would
No,
be your
because
position.
we trust, the Supreme Court has said we trust the American people.
Oh,
The American people, no, it's what is in common use by law-abiding Americans, and so we trust them to make that choice. That is the choice actually the Constitution entrusts them with. And so if a manufacturer floods the market with something that is not useful for those purposes, law-abiding citizens will not buy it. That is the theory of the Constitution. So, thank you.
There
Your
also
Honors.
probably would be some, at some point, would be some common sense.
Yes.
that's what I'm looking for.
All right, thank you. We would normally come down and greet you. I forgive my little talk, and you've heard it, and we regret that we're not doing it, but we thank you for your arguments, and we hope you come back. Actually, Attorney General Frosch is here, but I'd like to recognize you. It's from Maryland. You're one of our prime citizens, has served the state for a long time. I think you're now turning it over to somebody else, aren't you?
I am indeed, Your Honor. I will not be back here as Attorney General.
Well, we'll welcome you back anyway and whatever.
Thank you
We'll
so
remember
much.
your past service and current service. Thank you
you
very
so
much. We'll proceed on to the next case.
Occurred at Topsail Middle School in Pender County, North Carolina. An autistic child, middle school student, according to the complaint, had an outburst in the final class of the day. The plaintiff, Ms. Burns Fisher, was the teacher of that class, an eighth grade teacher. The student allegedly threw a book bag and then assaulted the teacher when he became agitated. My client, Dr. O'Mara-Lair, was the principal of the school at that time. And according to the complaint, and I believe it's paragraph 15 of the complaint, the child identified as TB in the complaint was an autistic child who had an IEP, an individual education plan. Those are required by federal law. As we pointed out in our briefs, federal law also specifically requires that autistic children and other children with similar disabilities be educated and placed in what's called the least restrictive environment. So just to give you a little background on that process, what happens is that a team meets and determines what the plan is for this child, and then children are placed in that. The plaintiff's allegations in this action are essentially that the teaching assistant didn't show up that day for class, and my client, the principal, nevertheless required the class to go forward. And this is what she claims, what the plaintiff claims, was a violation of her due process rights under the state-created danger theory. When we moved for qualified immunity in this one, and the court, again, I know you've seen it hundreds of times, the qualified immunity process, there's two prongs to the defense of qualified immunity. The first question is, do the facts as alleged establish a violation of the plaintiff's constitutional rights? And then the second prong is, if the plaintiff prevails on the first one, was the law clearly established in a concrete and particularized manner at the time? Qualified immunity is denied only if the defendant loses on both of those prongs. Now, in this instance, in this case, we believe that the plaintiff loses on the first prong and that it's not even a close call. The lead case in this, as we pointed out in our brief, the case that sets the background for due process claims by public employees who are challenging the safety of the workplace, is the Collins case from the Supreme Court. It's a 1992 case. And one of the cases, I believe it's Witkowski, is an out-of-circuit case I pointed out in our opening brief. I want to say it's a Seventh Circuit case, maybe from 2006 or 7, pointed out that since Collins at that time, in the 15 years at that time, that panel had not been able to find a single case where a public employee had prevailed on a state-created danger theory. And I'll submit to you that in our briefing, one thing that should stand out to the court is that neither the plaintiff or my client has been able to find a case either. Not just from this circuit, but any circuit. So the case law that we do have on state-created danger claims by public employees, and we started with the Waybright case cited in our brief in 2008. It's a fire department worker that died in training, and the court found that's not a state-created danger. Judge Niemeyer, you were the author of the Slaughter case in 2012. Again, it's another fire department case. A live burn exercise, a fire department trainee died and essentially claimed that by subjecting him to a hazardous workplace, his constitutional rights were violated. And I want to focus on the Slaughter case for an important reason, because Slaughter...
I hope it's not because I'm sitting on this panel.
Well, that's certainly not one of the things that I ignore, but Slaughter pointed out that the standard for these claims isn't just deliberate indifference. It's higher even than that. The claimant has to allege and prove that the public employer actually intended to harm them. And that holding was repeated in the Callahan case last year. That was a prison worker who was killed by an inmate. And Judge Richardson happened to be on that panel. Earlier this year, or last year, another case, Howe versus Correctional Enterprises, also cited in our brief, another prison case, repeated for the third time that the standard is an actual intent to harm. The plaintiff has to prove that. Now, we pointed that out at the district court level, pointed out in our opening brief again here, and the plaintiff never addressed that argument. Never addressed that argument. That has not been alleged in the complaint. And I don't think consistent with Rule 11 they could. So, Your Honor, again, all of the case law from this circuit has declined to find the right that the plaintiff is asking for. There has never been a published Fourth Circuit case finding a violation of rights under the state-created danger theory for a public employee. So we believe that the case law is clear and that our client should prevail on the first prong. And I'll go ahead and ask you, even though we could win on either prong, and under Saussier's, well, actually under Pearson versus Callahan, as you're well aware, you've got the discretion to skip to the second prong of the qualified immunity argument and just decided on that. In the interest of judicial economy, because the school board's still left in this case, we'd ask that the court address and decide the first issue, whether there's a constitutional right at all. But if you decide for some reason to break with your prior holdings and find one here, it would create a circuit split. Because as we pointed out in our brief, we can't find any case law supporting the plaintiff in the Fourth Circuit. Looking outside the Fourth Circuit, if we look at a concrete and particularized set of circumstances, one that's similar to this, we pointed out at the district court level cases from both the Seventh and the Sixth Circuits that both involved public school employees being assaulted by autistic children who had IEP plans. And in both of those cases, and they're both published opinions, they're the Jackson Prairie opinion and Jackson versus Indian Prairie School District and Hunt versus Sycamore Community School District. From the Sixth Circuit and Seventh Circuit, the last one, the Seventh Circuit one, is 2011. But in both of those cases, those panels decided on the first prong of qualified immunity. They said no violation. So turning around to our qualified immunity precedent and asking, what would my client, that's the question, the relevant question for you, what would a reasonable official at the time see as the law on this? If my client were a Fourth Circuit judge, even, she would look around and see there's no case law from our circuit ever recognizing such a right, and published case law from two other circuits under the same set of circumstances saying the right doesn't exist. There is no way that provides the type of clear notice that's required to strip qualified immunity. Now, I would like to be able to explain to you how, and I'm getting down on my time here, how Judge Dever, how the trial court erred in their analysis of this, but I can't because there wasn't any provided. As you saw in the joint appendix, the decision provided no rationale at all. It was just a simple denial. It's on page 32. Just says the courts reviewed the plaintiff's complaints and the defendant's motions to dismiss under the governing standard. The court denies defendant's motions to dismiss. And then goes on to tell us that the magistrate judge is available for a settlement conference. Now, one of the things that was frustrating about that was that my client's motion to dismiss wasn't just qualified immunity, but also raised the argument that when you're brought in to represent official capacity, defendants nominally sued, you often point out under Kentucky versus Graham, that's surplusage. You don't even have to go forward with you've already got the school board in, there's no need for a separate official capacity claim. That wasn't even contested at the motion to dismiss stage, and it was denied anyway. So we are here to try to resolve this one, hopefully as quickly as possible. We don't believe that there's any possible reasonable view of the case law that would result in qualified immunity being denied. And in your discretion, we would ask that you address the first question, the first prong, and hold that no such right existed. Thank you, Your Honors. Are there any questions?
Mr. Berger.
Thank you, Your Honor. May it please the court, my name is Bruce Berger. I represent Miss Kimberly Burns Fisher in this case. Would respectfully disagree with counsel on both points because we believe that this circuit in several cases, including most recently the Callahan case, prior to that the Doe versus Rosa, and prior to that the Pender case, clearly establish that there is a constitutional protection for a state-created danger theory
under a state-created danger theory, and that there is a constitutional protection, due process protection, for a violation of a liberty interest for bodily integrity. The cases in this circuit have discussed that. Cases in other circuits have discussed that. So we think, with respect to counsel, that that is clear. And what we think is really important is
I guess his point is, I don't think he disputes that. I think his point is, have we ever found that a state-created danger was present to allow a case to go forward?
But I think
and we had some pretty difficult cases, where they released somebody who was under a warrant for arrest and goes out, they released him and he killed somebody, and I think we had that twice, and we had the Byrne cases, 2 of those, and all of these were alleged to be state-created dangers, and so do we have something that helps you in finding where one was actually found to exist?
The one that I saw, Your Honor, it's an unpublished case, admittedly, but Fourth Circuit, Robinson versus Loy, which we do cite in our brief and mention that, and to your point, I think that the sad part of these cases is the results are terrible. Somebody's badly injured and you're dealt with an injury.
It is, and I empathize with it. I mean, without reaching any formal thing, that it looks like the teacher she was sort of left unprotected, and they had policies in place and so forth. But I gather the underlying policy to try to guide these cases in the right channels is that the tort law should be able to take care of that, and that we shouldn't constitutionalize every tort. And that, I think, is probably one of the strongest bases why the courts have been resistant to elevating torts into constitutional violations. Because you do have a tort claim, don't you, outstanding?
We do in the state case. But can I address that, though?
Yes,
because I think that's an excellent point. What the case law is very clear on is exactly what you said, beginning with the City of Sacramento versus Lewis case, U.S. Supreme Court case. And that's where I disagree with the intent. Let me, 2 points. One is there's a spectrum here between tort law, which I completely agree under the facts. If it was a simple negligence case, what the courts say clearly is there is no constitutional violation. On the other hand, what the courts say is if there is intent, then there is most likely a constitutional violation. Mr. Blanchard is correct. We have not alleged intent here because we haven't done discovery. Is there intent? Don't know. We don't have a smoking gun letter. We don't have a confession, those sorts of things. I truly doubt whether those things exist. But what we do have are actions that we believe and have alleged go beyond simple tort, and which we've also alleged, by the way, in state court, well beyond, although...
Well, the tort law is not inadequate, is it? Don't you like tort law?
Well, yeah, I do like tort law, but so, interestingly, in state court, we have also alleged a significantly stronger set of facts beyond simple negligence. That's really the point. And in this case, we've alleged deliberate indifference, which I believe under the law is sufficient in that spectrum between simple negligence and intent, number one. Secondly, I think this is also
What's the case that suggests in a state-created danger case that deliberate indifference suffices?
Yes.
What case?
What case is that? I believe we cite that in the brief. I think there's I will try to locate that in my notes, but I believe that there is, Lewis certainly says that in the spectrum between
but Lewis in the state-created danger case, right?
No, it was not. Lewis? Mm-hmm. Now, what it said was, though, that there was a spectrum that allows you the constitutional action. I think if there's negligence, you don't have it. If there's intent, you do. And they were saying that there's a spectrum between there, and deliberate indifference would be part of that spectrum.
But the question is whether it applies, but what Lewis says is sometimes that's going to be enough and sometimes it's not, right?
Right.
Depending on the nature of the action.
Oh, absolutely, which gets down to really my point at this stage of the litigation. I think the cases are clear on this too, that each case, because they are difficult cases, as Judge Niemeyer said, each case depends on the specific facts of the case. And what we have here, I would suggest to you, because we're dealing with a motion to dismiss and not summary judgment like the cases that counsel cited, what we have here are facts that allege, taken as true, which I think you have to do at this stage of the litigation, would give rise to something much greater than negligence, possibly intent. We haven't alleged intent because we don't know it's there, but it would be that spectrum, on the spectrum close, which would be deliberate indifference.
What is the affirmative act that's alleged in your complaint?
I'm sorry, Judge.
What is the affirmative act that's alleged in your complaint?
The affirmative act is that with all the knowledge of the prior actions of this child, with all the rules in place, with all the safety precautions in place, on that day, this teacher who had been attacked by this child on previous occasions, called the principal and said, from the classroom, and said,
Right.
so I think that the affirmative act is principal shows up, sees that that is not the case, and says to the teacher, teach the class anyway. So she's instructed to teach the class despite the knowledge with this child in the class, with the prior attacks, without the safety rules in place. I think that's the intentional act.
But with respect to the danger, it's really a failure as opposed to an affirmative act.
Well, I think the affirmative act is...
The principal just didn't act on it and left. She didn't create the danger. She failed to act to protect.
Well, the creating the danger, I would submit, is requiring the teacher to teach with that knowledge and with those rules in place.
She had a pre-existing duty to teach. She was hired to teach.
She was hired to teach, and she had a pre-existing duty to teach, but she didn't have the duty to teach necessarily without those safety.
Why isn't this just like Callahan, right? The argument in Callahan was, like, I'm a jailer, like, you got all these rules, I need more people, you don't give them to me, you put me in the pod, and I get killed.
I think
Same basic story, right? It's just that the student is not as bad as the inmate, but otherwise.
Well, except that in this case, what you have, I think you have two things. I think you have, one is specific prior acts against this teacher. That was not the case in Callahan. There were no...
That goes to knowledge, but it doesn't establish an affirmative act.
Well, the affirmative act here, again, and I don't recall in Callahan that the corrections officer was told, you have to work this day, that she raised that issue that day, right?
But that just goes, okay, I understand your argument.
Well, right, and I
So the
think
affirmative act was telling her to do her job?
affirmative act was telling her to do her job in light of the knowledge of a potential danger and in light of the knowledge of no second
Right.
teacher there.
And when you add that in light of part onto your response, you get back into what Judge Niemeyer was saying. It sounds like reframing the issue into a failure to protect rather than an affirmative act.
Well, I think that, to me, the failure to protect issue is much closer in the Callahan case than it is in this case. And I think the reason is the prior knowledge of the specific violent acts against this teacher and the prior knowledge of the fact that that day there were the safety precautions were not in place, and the knowledge that that day, not a week before like in Callahan or several days where the inmate had suggested that he was violent. You have the immediacy of what occurred in the presence of numerous prior actions, and despite the teacher's concern, which was expressed that day, she was still told, you have to teach without these precautions in place. That's what I would suggest is the affirmative act.
Okay.
Sure. Can I add one other thing to that? Because I think it's also important. Unlike, in one of, I can't remember which of the fire cases, there was a training case, and I believe it was this court that said, you could have just not gone to the training. You could have said, I'm giving. Here you had a class full of students when the teacher was aware that there was no second teacher there is required. When the principal said, teach anyway, the teacher couldn't say, I'm out of here, because you had a class full of students. She didn't have that voluntary aspect of not being able to carry out her job that day. Judge Niemeyer, I'm sorry.
Yeah, no, I thought you were at an end, so.
Oh, okay.
You have time.
All right. Well, that's our essential question. I think that the cases are clear that you need to look at the specific facts of the case and the temporal nature, and I think that's why Callahan is in large part different. The temporal nature of the actions to the injury, and in this case, they were immediate, like within, 40 or 50 minutes, with all this prior knowledge. I think that's what makes this case stand out, and why, when you look at the facts of this case with this teacher and this child and what happened that day, that we believe there is sufficient evidence alleged to go forward to at least discovery to see whether or not that intent is there and see what other factors there may be. We haven't had that opportunity in this case, and we believe the court should affirm, therefore, the district court's ruling and allow discovery to take place.
Okay.
Thank you.
Thank you, Mr. Berger.
Your Honor, may I
Mr. Blanchard.
very briefly on rebuttal? The first point I'd like to make, and this addresses both Judge Thacker, your question, Judge Richardson, yours. I think it's vitally important to point out here that this is the public employment context that we're talking about, and many of the cases for state-created danger deal with the private sector, just citizens filing these claims against government actors. In the public employment context, the argument that deliberate indifference is good enough is plainly contrary to your precedent and your recent precedent. Judge Richardson, you were on the Callahan panel, as you pointed out, just last year. I'm looking at footnote 5. In the context of voluntary public employment, to meet the arbitrariness requirement, the government employers only shock the conscience if they, quote, intend to harm, end quote, the employee. Now, that's a direct quote from the Slaughter case, a published opinion that's binding precedent on this court. So I've pointed you to two binding decisions here that reject, in the public employment context, the idea that deliberate indifference is enough. And that's an important thing, because we look at this. One of the reasons the standard's higher for public employees is because a lot of dangerous jobs are left to public employees. You got U.S. Marshals here who theoretically would have to fend off people with guns. But there are all kinds of other jobs. The Collins case in the Supreme Court, the plaintiff was a sanitation worker who suffocated in a sewer. You think about it. School teachers, I've cited two of them already for you. I'm dealing with students with IEP plans that are, let's face it, prone to outbursts. They're unpredictable. That's why they have a professionally drawn IEP plan, like they did here. So there's a good policy reason for having that higher standard in the public employment context. To your question,
I think
Judge.
the higher standard should be fairly attributable to a constitutional claim. In other words, the Constitution does not intend to supplant the tort law.
It's a tort law, you're right, because it constitutionalizes the tort.
We require that the tort law be committed to such a degree of depravity that it violates substantive due process, and even substantive due process is an area where the Supreme Court has put on the brakes. They just do not want to expand the Constitution.
You're preaching to the choir, Your Honor. You're not here. We're not here to create a fine of tort law.
The fact is that all of these points, there may be deliberate indifference, there may be recklessness, there may be other types of things, But we do have a body of law that'll address that, and hopefully, if there was a wrong committed, that the wrong will be redressed.
And yes, and I was just very briefly, I'm about to run out, Judge Thacker, in response to your question about the Affirmative Act. Failing to protect people from known dangers has consistently been held to not be an affirmative act. And strangely enough, there's an unpublished case, Fletcher versus Maryland Transit admin, where neighborhood residents filed suit claiming that they were not protected from students, high school students, unruly high school students in the area. And this court found that, hey, those high school students were a pre-existing danger, not a state-created one. So that's, you're right. All of these cases, that's the one thing that's in common. Plaintiffs are coming in trying to shoehorn what's essentially an allegation of failure to protect into an affirmative act because they know they have to do that to get into court. But here, all the case law, literally all of the case law goes in one direction, and it's in favor of the defendant. So thank you again, Your Honors.
All right, thank you, Mr. Berger. We are going to forego coming down to shake hands with you. We'll do it the next time you come, I hope, but we're still under the protocols. But thank you for your arguments, and we'll stand adjourned.
Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.